Welcome to Sunday and welcome back to the drama-free true crime destination known as Bethea'S Byte Reloaded. I am Ernest Bethea, the last outlaw. So good to have you here this evening. And we are going to court. That's right, court's in session this week because we got nothing but mostly trial updates. We're talking about cases like we're going to be updating Idaho versus Bryan Kohberger, Arizona versus Lori Vallow Daybell, the battered and burned retrial, Michigan versus Linda Stermer, and the retrial that everyone's going to be talking about this week, round 2, Massachusetts versus Karen Reed. All that and so much more this week, so we're going to kick things off with this story, or an update of a father rejecting a plea deal in regard to his child's death in a hot car. Let's get started. An Arizona father is accused of leaving his 2-year-old daughter in a hot car, leading to her death. And he has rejected a plea deal and is now going to face trial on first-degree murder charge. Christopher Schultz appeared in court where prosecutors confirmed they had offered him a deal to plead guilty to second-degree murder, which carries a sentence of 10 to 25 years in prison. Schultz declined the offer, meaning his case will go to trial, where he now faces the possibility of life in prison if he's convicted. Schultz was initially charged with second-degree murder after telling investigators he left his daughter in the car with the air conditioning on, something he admitted he had done before. However, on the day she died, the car shut off, leaving her trapped in extreme heat. A grand jury later indicted him on first-degree murder, significantly increasing the potential penalty that he faces. With the plea deal no longer an option, Schultz's trial is scheduled to begin in October. He also faces a second count of a Class 2 dangerous crime against children, which carries a sentence between 10 and 24 years. The presumptive sentence is 17. If convicted on the first-degree murder, he could spend the rest of his life in prison. The judge says both would be flat-time sentences, meaning Schultz would receive these sentences if convicted without the possibility of parole or other forms of early release. Let me go ahead and translate that for you guys. If he's being sentenced to life in prison, that means he's going to literally spend the rest of his life in prison. Parole, forget it. Early release, forget it. Nothing of the sort. He is done. If on the other hand if he gets the class 2 dangerous crime against children sentence and the presumptive sentence is 17 years, heads up folks, he's doing all 17. No parole, no time off for good behavior, he's doing 17 years. Maybe in that time frame, he will learn the hard way. Pay attention to your surroundings in a hot car. The last person you want to leave in there is your child. But wait a minute, I'm getting just a tad bit ahead of myself. I'll wait to drop that PSA this summer, right around, say, the crack of Memorial Day. Next up, prosecutors say that this teen literally lived with the bodies of his mother and stepfather after killing them. We're coming out of Wisconsin with this. Prosecutors would have charged a Wisconsin teen with first-degree intentional homicide after they said he murdered his mom and stepdad, then lived with their bodies for 2 weeks. Prosecutors say Nikita Kasip, 17 years of age, shot and killed his mother, 35-year-old Tatiana Kasip, and her husband, 51-year-old Donald Mayer, inside their Waukesha home in February. The Waukesha County Sheriff's Department found their bodies on February 28th after deputies were called to the home for a welfare check by Mayer's mother in Massachusetts. Tatiana was found in the hallway, covered with blankets and a towel, while Mayer was found in a first-floor office. Prosecutors said Nikita has also been absent from school for 2 weeks. Nikita is facing 2 counts of first-degree intentional homicide, 2 counts of hiding a corpse, 2 counts of theft movable property, operating a motor vehicle without the owner's consent, and 2 counts of identity theft, financial gain, according to a criminal complaint. According to the complaint, Nikita was taken into custody in Waukene, Kansas during a traffic stop. A previous emergency phone ping showed Nikita and one of the victim's phones in Cheyenne, Wyoming. In court earlier this month, prosecutors said that on February 11th, Nikita shot his mother at least 3 times, twice in the stomach and once in the neck. Nikita allegedly killed his stepfather by shooting him in the back of the head. He then went to school the next day and continued living at home for nearly 2 weeks until February 23rd. In court records, Waukesha police said they found a camera memory card that showed Nikita was lighting candles in the office where Mayer's body was and was sitting and recording the dead body about a week after the murder. Police said at one point Nikita stood next to Mayer's body with his phone out as if he was going to take a picture, all while videoing himself with the other camera. Nikita then said, "So you can see him there. I can literally see the expletive rotting body." The defendant continued to live at the residence with the 2 bodies at the house. He then fled with the $14,000 in cash, prosecutors said. We know he was communicating with someone to get fake plates put on the car to hide that the car was stolen. Prosecutors said after their deaths, Nikita was communicating with someone either in Russian or Romanian. Nikita is originally from Moldova, and his living relatives are mainly overseas. It appears this individual was trying to flee the jurisdiction, not only this state, but this country, said Christopher Bailey, the Waukesha County Court Commissioner. A lot of these issues make the court believe that this individual had no intention to be here where he is today. This kid has a lot of issues, my friends. A lot of issues. So, this case is going to take a lot of twists and turns even before it gets to court. So let's get ready for all that. All right. The first update in Arizona versus Lori Daybell is the who's who in the world of Chad and Lori Daybell. Alright, here we go. Lori and Chad Daybell were both convicted in the deaths of Lori's 2 youngest children, J.J. Vallow and Tylee Ryan, and Chad's first wife in Idaho. Lori was sentenced to multiple life sentences without parole, while Chad was sentenced to death. Now, Lori is acting as her own attorney as she stands trial in Arizona for the death of her 4th husband, Charles Vallow, and conspiring in an attempt to kill her niece's ex-husband, Brandon Boudreaux. Some witnesses who testified at Chad and Lori's trials are expected to appear during Lori's Arizona trials. Before we look at those people who were involved in those cases, let me say this once again, because remember, there has been only one time, once, where a defendant has advocated for themselves and was able to get himself acquitted of the charges against him. And to this day, I congratulate him for doing that, because that has never been done before. And quite possibly, I will likely be dead and gone before it ever happens again. So now that I got that clear, let's break down who's who. Introducing first our defendant, Lori Vallow Daybell. She was born to Janice and Barry Cox on June 26, 1973. She's the middle of 5 children, including her older brother, Alex Cox. Lori's been married 5 times, with her first marriage to her high school sweetheart when she was just 19, according to the Associated Press. Lori married Nelson Yanis in 92 and divorced shortly thereafter. Her second marriage was to William Lagiola on October 22nd of 95. She would give birth to a son, Colby, before divorcing Lagiola on February 25th of 98. Again, that's according to the Associated Press. 2001, she married Joseph Ryan in Hawaii, though they lived together in Texas at the time. On September 24th, 2002, Lori gave birth to Tylee Ryan. Lori and Joseph would divorce on May 18th, 2005. Lori married her fourth husband, Charles Vallow, on February 24th of 2006 in Las Vegas. In 2013, the couple adopted JJ from Charles's sister and her husband, Kay and Larry Woodcock, who were JJ's grandparents. In 2016, the couple moved to Arizona, where they settled down with Tylee and JJ. 3 years later, Charles filed for divorce, indicating he was concerned about her mental health, according to the East Idaho News. Lori's older brother, Alex Cox, fatally shot Charles on July 11, 2019. Lori married Chad Daybell shortly after Charles' death on November 5th of 2019. According to the Associated Press, Lori was a beautician by trade. The prosecutor says she stopped working and began stealing Social Security benefits to fund her lifestyle. Next, we have convicted murderer Chad Daybell, who was a member of the LDS Church and a self-published author of doomsday-focused fiction. Chad was charged alongside Lori in Idaho, but had his case severed from his wife's. Chad married his first wife, Tammy Daybell, on March 9, 1990. The two would have 5 children together, according to the AP. While in college, Chad worked part-time at the Evergreen Cemetery and was later hired as a cemetery sexton. In 2004, Chad and Tammy founded the Spring Creek Book Company, with Tammy serving as chief financial officer. The book company served as publisher for Chad's writing. Chad met Lori at a 2018 conference in Utah, where the two felt an instant connection, according to testimony. Friends of the couple who witnessed their meeting said the two claimed they had been married in past lives. Chad preached about a light and dark scale for followers and claimed that zombies were able to possess a person's body. Chad claimed that the only way to get rid of a zombie was to destroy a person's body, according to testimony during his trial. Now, anybody who fell for that really and truly needed their head examined. Lori, I'm talking to you. Anyway, those are just Chad and Lori. There's so much more. We have Charles Daybell, who's Lori's fourth husband. Tammy Daybell, Chad's first wife, Tylee Ryan, who was killed, J.J. Vallow, who was killed, Alex Cox, Lori's oldest brother, Zulema Pastenis, who is married to Alex 2 weeks before his death. Lori's son Colby, followed by William Lagiola. Kay and Larry Woodcock, the vocal grandmother and grandfather who we've seen during Chad and Lori's trials. Melanie Gibb and David Warwick. Melanie was one of Lori's closest friends, and David Warwick is Melanie's boyfriend. Then there's Melanie Pawlowski and Brandon Boudreaux. Melanie's Lori's niece. Brandon Boudreaux was previously married to Melanie. Melanie remarried to Ian Pawlowski on November 30th, 2019. There's April Raymond, who lived in Hawaii and taught scriptures in Sunday school with Lori. Serena Sharp, friends with Lori, and was mentioned by both Melanie Gibb and Zulema Pastenis in testimony. Samantha Gwilliam, Tammy Daybell's only sister. Alice and Todd Gilbert, Chad's neighbors, who lived down the street from him and Tammy Daybell. Audrey Baratario, a follower of Chad's who first met him in an event in St. George. And that's it. That's pretty much everybody involved. There's still more updates coming in this edition of Bethea'S Byte Reloaded regarding Lori Vallow Daybell and her case, where again, by the way, she is representing herself. And oh my goodness, who do we have here? Hollering at me? April. Good to have you on, April. Nice to see you. Welcome to a trial update edition of Bethea'S Byte Reloaded. Man, oh man, we got so much to cover. The next story I'm gonna hit right now. A wife is arrested after the remains of her Green Beret husband was found in a pond. I'll give you part of it, and I'm gonna take you to Court TV for coverage. Right now, this is coming out of Cumberland County, North Carolina. Sound like my old digs. A North Carolina woman has been arrested in the death of her former Green Beret husband, whose body was found a month later after he was reported missing. 50-year-old Shauna Cloud was arrested on last Friday and charged with first-degree murder and a concealment of death, according to the Cumberland County Sheriff's Office. An arrest warrant was reviewed by Court TV and accuses Cloud of killing Clinton Bunnell and concealing his death while knowing Clinton Bunnell's death was not due to natural causes. Bunnell was reported missing on January 28th after failing to show up for class at Methodist University. At the time of his disappearance, he was studying to become a physician's assistant, according to authorities. He had retired from the U.S. Army in December. While authorities arrived at the couple's home, Cloud told deputies she had not seen Bunnell since the day before. Yeah, good to see you. And you asked a great question. How does one unalive a Green Beret? Well, we're about to dig in right now and find out exactly what this young lady, and I'm being real careful about this. We're gonna find out exactly what this young lady is really being accused of. So, we're going to take you to Court TV and let's dig in.
Welcome back. And now for what's trending in true crime. The wife of an Army Special Forces officer is charged with his murder. But it's what the victim's girlfriend is saying now that's trending this morning. So the suspect and the estranged wife, Shayna Cloud, was arrested on Friday and charged with first-degree murder after investigators say that she shot and killed her husband, Clint Bonnell. And Bonnell, who is a retired Green Beret, was found 3 miles from their home in a rural pond. Now, this was nearly a month after he was reported missing. But now, Bonnell's girlfriend is speaking out, telling ABC News about the separate lives that he and Ms. Cloud were living.
I know that they were coming to an end. And, the last couple of weeks, 5 or 6 weeks, things were really shifting. There were some concerns, for sure. And obviously, no one understood the severity of those concerns.
Now, police say that Bonnell was in the process of filing for divorce, and they think that that might have been the motivation behind his murder. We're asking this morning, should investigators be looking at anybody else besides Shayna Cloud? Let's talk about it. Still with me, Mario Gallucci, and want to welcome in high-profile attorney John Phillips. Good morning to you, John. Let me start with you. Your thoughts on this? Should they be looking elsewhere?
You gotta start with the window really wide open as a prosecutor, as Cumberland County Sheriff's Office in North Carolina. And try to figure out where things, went wrong. And it leads to the girlfriend who was making welfare checks or asking for welfare checks. And it leads to the wife, and it leads to this messy divorce. And look who's talking, right? So they've kind of triangulated the situation. They've gotten other evidence to corroborate their suspect. They found other evidence to show that she was in the area. You expect her to try to point the fingers, or a defense team to point the fingers at somebody else. But I right now, everything's pointing to Shayna Cloud.
Right. You're right, John. You're right. Mario Gallucci, same question to you, please. Should they be looking elsewhere?
Well, as a defense attorney, you're always looking elsewhere. But in this case, I would say I would use what I call the Dexter defense. The body was found dismembered 3 miles away in a pond. That is not something that a woman can easily do to a Green Beret. So the allegation is that not only did she kill him, but she dismembered him and moved him over 3 miles. So it's a Dexter defense. I want to know how they're going to be able to show that she was able to do that. And from what I've read so far, there's been no forensic evidence found at the scene to indicate that that was done. So it's going to be a very interesting trial. Very interesting.
Yeah, you're right, Mario. So there's more coming from Clint Bonnell's girlfriend this morning. Take a listen to what Kelly Edwards told ABC News about how Bonnell appeared the day before he went missing.
He was really exhausted that day. He had been kept up the night before. You could tell he'd been through a lot. He was just a jovial, happy human, and he was really looking forward to his next part of his life, closing a chapter, coming out of the Army after 20 years.
All right, so we have some more details into the investigation, and in particular, why they like Shayna Cloud for the homicide. So she told police she last saw Bonnell on January 27th. He was reported missing on the 28th. Forensic investigation led to police obtaining search warrants for her car, her rental property, and her cell phone. And we also know, as mentioned, that Bonnell was planning to divorce Ms. Cloud. And so finally going to break that tie. Now, Ms. Cloud was denied bond on Monday. She's due back in court for her next hearing on April 17th. And so we're wondering, what's going to be the best defense strategy for her? Mario Gallucci, let me start with you here, please.
So as I explained, this is clearly going to be a Dexter defense. We all know the TV show Dexter, where he plans out a murder and he's able to dismember bodies and to dispose of them. You're asking a jury to believe that this young woman was not only able to take over a retired Green Beret, but then dismember his whole entire body and move him 3 miles. I have seen no forensic evidence. I know that they have warrants for the car. You would expect to see some of his DNA in the car. You may, to dismember a body and move it 3 miles would be very, very difficult for this woman to do by herself without leaving any evidence. And so far, we've seen no evidence of that.
I love what you're saying, Mario. The Dexter defense. I love that. And, you know, by the way, what a small world it is. So M. William Phelps, one of our guests who's been coming on the program recently, we love him. He consulted on the show Dexter. He's a really accomplished author, a true crime writer, and podcaster. So cool stuff with that. John Phillips, I want to share with you this statement that Clint Bonnell's family issued. And this was issued right after his estranged wife was arrested. So take a look. It says, Clint was an incredible human who sacrificed so much for others and dedicated his life to the betterment of this world. All we can do now is pray for swift and just punishment for Shayna Cloud. John, tell me, it makes me think, you do civil work as well as criminal work, makes me think, is there a civil lawsuit that could potentially be brought here depending upon what happens in criminal court?
There certainly is. His family can always sue, her and those involved. And I've watched every episode of Dexter so far too. And Dexter liked his victims to be punished, right? And the gunshot wasn't Dexter's way of killing somebody. And so certainly, it's the dismembering that is particularly hard about this case, but it also would allow her to more easily transport it to a bond. But it's certainly a civil case, as the public and prosecutors and police only give us a little bit of information. And as we sit here and follow this case more, we'll certainly learn more and be able to extrapolate new ideas and theories.
Yeah, isn't that the truth? This one, in the early stages, and you both know, this is going to be very high profile. It's already circulating, making headlines all over. So we're not done. And certainly we're grateful to Clint Bonnell for his service.
Thanks to Court TV's Julie Grant and her two guests. And April is saying the same thing. I'm thinking already, saying, well, now she's gonna lose it all. Which I agree with that. But I also see there could be other people involved in this mix too, because like one of the guests said, how in the world is she gonna be able to dismember somebody and move the body, or parts of the body in this case, by herself and leave no evidence behind? That's just impossible. So I'm looking for the answer to a question that she brought up earlier. It doesn't say how long they were married. No, it doesn't say anything of that. They'll tell you that the body was found on February 25th in Rural Pond, 3 miles from their home. However, the remains weren't confirmed to be Bonnell until a month later, on March 28th. A 911 caller who reported finding the body said it appeared to have been dismembered. That's according to a report from WRAL Channel 5. Multiple search warrants were executed in the weeks before Cloud's arrest, which revealed Bonnell was planning to divorce Cloud, and the warrants say that Bonnell's girlfriend last heard from him the night of January 27th, when he texted her to say he told Cloud about the divorce and he was going to bed. She appeared in court, where she was denied bond, and her next scheduled hearing is set for April 17. And let's see what. Yeah, you're right. It's somebody had to have helped her with this. It's because, I mean, if I'm gonna dip into the criminal mind, if you will, it's gonna take some doing to unalive, dismember the body, and then be able to carry the body parts, dump it into a rural pond 3 miles away from home by myself. I don't think that it happened that way. I think she did unalive him. I think she did dismember, but I believe she had help in dumping the body. We'll see what we'll make of that as this case progresses. Next up, regarding the death of Oscar winner Gene Hackman, the judge raised the request to withhold investigation records. Honestly, this might be the one story I'm tired of covering. Let him and his wife rest in peace. Looks like I'm gonna have to go back to court TV. But anyway, a court on last Monday, cleared the way for the release of investigative records from the deaths of Gene Hackman and his wife Betsy Arakawa, as long as depictions of the deceased couple are blocked from view. The ruling from a New Mexico judge allows the possible release of redacted police body camera video and other investigative materials, including images of the couple's dead dog. All photos and video documents from the investigation had been restricted from release by an earlier temporary court order. There shall be no depiction of either body in any video production or photographic image of the bodies, Santa Fe-based Judge Matthew Wilson said in response to questions from attorneys on his ruling. A representative for the Hackman family estate had urged a New Mexico judge to keep records sealed to protect the family's constitutional right to privacy. Oh, going back to the last story. April says unless Shayna Cloud is a beast, some women are strong and with adrenaline. That I can agree with. To quote the late great Gorilla Monsoon, that adrenaline can do wonders. You never know. Anyway, we're gonna jump right into Court TV's continuing coverage. I don't know why, of the death of Gene Hackman and his wife Betsy Arakawa. Again, I still say let these two rest in peace. All right. Now that I've said my piece on that, let's go to Court TV's coverage.
We are bringing you a hearing this afternoon related to the death of actor Gene Hackman. The late actor's estate is trying to prevent the release of records from that investigation into the deaths of Hackman and his wife, Betsy Arakawa.
These records include footage showing the couple's bodies. Now, a court put a temporary restraining order on the release of the records pending today's hearing.
All right, let's get you back to court now, where the publicist for Gene Hackman is describing how private the actor and his wife were.
Ms. Brewer, did you know Gene and Betsy Hackman?
I did.
And how long had Gutman and Associates represented Gene and Betsy Hackman for? Excuse me.
Yeah, we've represented Gene since the beginning of his career, so about 60 years.
Can you briefly tell me about the Hackmans? What were they like?
Yeah, they were lovely, kind, wonderful, funny, private. Gene was a little shy and reserved until you got to know him. Betsy was wickedly funny. She had a really, really wonderful sense of humor.
You had said that you've worked for Gutman and Associates for 27 years.
Yes.
Did you work with Gene and Betsy for the entire 27 years?
Yes. Yes, 27.
Can you tell me, was privacy important to them?
Yes, very.
Do you know how long the Hackmans resided in Santa Fe for?
They moved there before I started working with them, so I would assume sometime in the 90s.
Do you know why the Hackmans chose to live in Santa Fe?
Yeah, Gene Gene made a movie in Santa Fe and really fell in love with it. He liked that it was remote and private, and he could have his anonymity there. He also, at that point in his life, had started painting, and he enjoyed that he could really experience an artist's life in Santa Fe.
Do you know if the Hackmans chose to live in Santa Fe having anything to do with their desire for privacy?
Yes, I believe so. They didn't like everything that LA had to offer them in terms of awareness. They liked their privacy, and they liked their private life in Santa Fe.
Do you have any brief stories that you could tell the court regarding any affirmative steps that Mr. and Ms. Hackman took to protect their privacy?
I do. I remember a couple of years ago, Betsy called. She wanted to let me know that they were buying a piece of land because Gene liked to ride his bike there, and he wanted the privacy of being able to ride his bike without anyone, following him or observing him. But she wanted me to let me know. She wanted to let me know specifically because the property is adjacent to the city dump, and she wanted me to be aware if anyone called asking why Gene Hackman lived at the dump, what it was about. More recently, in January or early February of this year, I was talking to a producer from CBS News Sunday morning, and they were asking for Gene to do an interview with them, and he had declined. And he had declined for years. And so they called to let me know that they were going to go to Santa Fe and do a piece on Gene without his participation. They were going to go to find people who knew them and get a sense of who they were and do the story that way. And when I told Gene and Betsy about it, they were horrified, really upset. And so I called the producer back and I asked them, can you please not? They would be really upset by this. And they agreed, and they decided not to do the piece. They didn't want to upset Gene and Betsy.
Thank you. Ms. Bedore, in your opinion, did Mr. Hackman take his name, likeness, and image seriously?
Very.
Did Mr. Hackman ever have a writer put into any contracts that you're aware of that might limit the publicity that he was to perform on a movie?
I'm not sure if it was ever contractual. I don't see those things, but for every movie he did, he only ever agreed to generally 2 hours of press on any movie.
Do you know if Mr. Hackman's movie contracts ever permitted him to retain the rights to his name, likeness, and image?
I believe they did, yes. Like, for instance, if any entity wanted to use a clip of Hoosiers in which Gene appears, he has to approve that first.
And did Gene ever deny the approval of the use of those clips?
Often. Yeah, very often. He generally approved things that were for artistic purposes, museums, art showings, things like that. But commercial usages, news programming, things like that, he would generally decline those.
Through your representation of Mr. Hackman, did you ever have to take affirmative steps to protect Mr. Hackman's name, likeness, and image?
Yeah, in the sense of correcting stories or turning things down, turning interview requests down, asking people to, leave them alone, nicely, no, sorry, that's not going to work, that sort of thing, for sure.
In your opinion, if the autopsy photos or videos or images of his last days or Betsy's last days were released to the media, how would this impact his name, likeness, and image?
It's interesting. It's an interesting question. I think that for anything like that to be out in the public, any entity can use it however they want, in perpetuity. And that's not something he would have never agreed in his life for that to happen. So why would we think he would agree to it in his death?
Can you tell me what steps your firm would generally take to counter negative publicity for a client?
Yeah, it would sort of be an all-hands-on-deck situation, really time-consuming, reaching out to every single media outlet, responding to every reporter, which is time-consuming.
Do you believe that the autopsy photos or videos and images of Mr. and Ms. Hackman's last days have any economic value if leaked to the press?
Objection.
Yes.
All right, overruled.
Can you repeat the question?
I think you answered it, but I will repeat it. Do you believe that the autopsy photos or videos and images of Mr. and Ms. Hackman's last days have any economic value if leaked to the press?
Yes, for sure. People could create movies, podcasts, anything, and they could monetize it.
And in your opinion, do you believe that the release of certain images and videos would negatively impact Mr. and Ms. Hackman's name, image, and likeness?
Yes, I do.
A lot of competing factors here in this case. Tough one for the judge, and we're actually waiting for a decision from the judge. He's expected to rule momentarily on whether to keep the injunction in place, preventing release of footage and autopsy reports. Let's bring back in our guest, still with us, criminal defense attorney Josh Schiffer. And Josh, as I said, there are competing interests here. You have what is arguably a public figure. He sort of retreated from that on a number of levels, and you heard the testimony there. Not something he embraced very often. There's laws that prevent certain images, including dead bodies, from being left out, but also there's the public interest. These are generally, a lot of the stuff they're asking for, public records. You want that transparency from government agencies, et cetera. What do you think about this situation?
You know, Michael, as much as he did step back, he also leaned in and aggressively monitored his name, image, and likeness. The steps that he took could seem something common, but only if you really are someone with a lot of notoriety, where people are not just going to use your name, image, and likeness for positive things, but for pecuniary gain, for maybe negative things. And so it appears Mr. Hackman was very proactive in getting his PR involved. They mentioned rioters, and obviously people have heard all about rioters. The idea that a major motion picture studio would give the ability to restrict media to a star in perpetuity, that's a pretty big deal. Most production houses, they want those movies everywhere. So Mr. Hackman, through this PR, is really trying to show the court exactly how tightly wound he was when it came to controlling his image, his likeness. I particularly like the anecdote about going and living by the town dump, because that's where he could go ride his bike as an old man. And I get that desire and the inability to control the press after such an amazing career. This is someone who was in movies for way more than my entire life, and he's legendary. So I get it. And I think the judge has a tough decision, but I think she's going to continue the injunction and allow Mr. Hackman's estate to protect the privacy and the value thereof, because remember, this is a property interest, really. Someone is going to inherit and manage a valuable asset, that being the perpetual name, image, and likeness of one of America's most beloved stars. That's a little bit different than me knocking off and someone making memes on the internet.
Yeah, no doubt. And to your point about the writers, it's often said in Hollywood that you're not necessarily paid for your acting in the movie, you're paid for the marketing of it after.
Yeah,
because it is
absolutely.
a drug. You're out there running around and you're doing all these things. So the fact that he was able to get a writer tells you just how serious he was.
Yeah, the likeness is absolutely a big part of the profitability of a star.
Yeah.
So, you know, I just have to push back a little bit, Josh, because it's so confounding to me to think if a person goes to this extent to protect their privacy, why in the world shouldn't it be private once they've died? Now, if there was a public interest, like, for instance, this was a murder, that might be a little bit different, but I just have a hard time figuring out any good reason why the public needs this information and why a permanent injunction shouldn't be issued in this case.
You know, there are those really good competing narratives, and I've got some big civil libertarian in me where I'm like, listen, when you're dead, these are records. These are public records for a reason. And it's tough. It comes down to some local control, whether you are a person of a certain level of notoriety, whether you are less protected because of what you've done in your life to put yourself or to end up in the public eye. There is that competing public interest narrative because people are hungry for news. And this wasn't a death that just, you know, faded off. There were some fairly intense bits of speculation still existing. And there are people concerned about what did or did not happen with an unbelievably tragic death. You know, even in its most generous terms, this was a really sad and tragic passing.
Yeah.
Yeah, and we're just learning that the judge actually denied any release as it goes to the audio that's involved in this case. Now, the thing I wanted to address, though, was something you mentioned earlier, Josh, and you talked about the value of his name, likeness, and image. And I have to say, in my mind, that value wouldn't be there unless he was a public figure. It is undeniably tied to the idea that he is who he is. And so that has to be factored in, this idea that it's only worth something because of who he was, and therefore the public should have an interest in seeing it.
And you're absolutely right, and it's going to depend on the demeanor of whoever manages that asset, what happens as time unfolds.
Yeah, this is one. I know all eyes are on it, but at some point, at what point does privacy control? That's what this court has to decide. It's not going to be an easy decision, I don't think.
Yeah, we would. I was saying at the as I'm watching the as I was watching the clip that I as an actor, I respected what Gene Hackman has done. In fact, I even said to April as the clip was about to end that I recognized Christopher Reeve as Superman. Conversely, I recognize Gene as Lex Luthor. Now, don't get me wrong. I've seen a lot of people play Lex Luthor on the small and large screen, and they've done a great job, but Gene Hackman, he made Lex Luthor as much a central character as Christopher Reeve did for Superman. That's why I respect him for that role. Again, I hope and pray that the judge will continue this injunction. Maybe that way that'll give the Hackman family time enough to sort out everything that needs to be sorted out, and at the same time, the public, as much as we do respect Gene Hackman, we can continue to let him and his wife and the dog rest in peace. Because that's the one thing the family is going to be seeking: peace and privacy. Okay, a little justice served as a twin offers a tearful apology at sentencing for lying about a deadly crash. Oh, and by the way, I want to send a special thank you and shout out to both Michael Ayala and Judge Ashley Wilcott at Court TV for their coverage on the Gene Hackman story. Now let's get to this one. Out of Preston, Minnesota, a woman who pleaded guilty to pretending to be her twin to take the fall for a deadly crash was sentenced to 90 days in jail. 2 children were killed and 2 others injured on September 25th, 2023, when a silver SUV crashed into an Amish buggy pulled by a horse in rural Minnesota. At the time of the crash, Sarah Beth Peterson, with this is the young lady on the right hand side, told officers at the scene she had been behind the wheel. An investigation revealed that she was covering for her twin sister, Samantha Jo Peterson, on the left, who was accused of being under the influence of methamphetamine at the time of the crash. Investigators said that Sarah tried to take the blame for the crash because Samantha had cared for Sarah's children while Sarah was in prison. Sarah was previously convicted on federal charges of conspiracy to distribute a controlled substance on January 10, 2022, and was on parole at the time of the crash. Sarah addressed the court at her sentencing, offering an apology to the victims of the court, saying, "I deeply regret the pain my actions caused the Miller family and the entire Amish community." She said through tears, "No words can possibly make their hearts hurt any less." She confirmed that she lied in an effort to protect her sister. "My first instinct was to try to shield her from any harm." Sarah initially faced 16 charges, but pleaded guilty to 2 amended counts of taking responsibility for criminal acts of another. The terms of the plea agreement spelled out a state sentence of 14 months for one count and a maximum sentence of 19 and a half months in prison on the second. But the state agreed to recommend a downward departure and no more than 6 months in local jail. In a filing on last Monday, prosecutors asked for a 4-year stay of the presumptive sentence of 19 and a half months, but asked that Sarah be required to spend 6 months in Fillmore County Jail. Handing down the sentence in accordance with the plea agreement, Judge Jeremy Kleinfelter described Sarah as a, quote, particularly amenable to probation, and commended her for demonstrating accountability and remorse. But Judge Kleinfelter pointed to Sarah's history of convictions of lying to police and pretending to be her sister as the reason why she would have to serve some time in jail. You're not a risk to public safety. This was not your conduct that caused the tragic events of that day, he said, addressing Sarah. You and your sister have apparently been doing this, at least in your instance, for some time. That should have ended in grade school, fooling the teachers. Though prosecutors wanted Sarah taken into custody immediately, she was given until April 23rd to report to jail to serve her sentence. Samantha is due in court on June 9th for a plea hearing in her case, where she's facing 21 charges, including several charges of criminal vehicular homicide. And yes, you're saying exactly what I'm thinking. Wow. I mean, sure, you're twins. Sure, your first instinct is going to be to protect your twin from harm. But the only thing is, your twin's responsibility is literally to do no harm. Sure, it may have been accidental, but really, when you're hopped up on methamphetamine, do you really belong behind the wheel? Number one, and number two, you did it. Should you really rely on your twin to bail you out? And on what really happened here is your twin was ready to take the fall for you. Now she's got to spend then 3 months behind bars just for lying to police, saying she is you. We need to start using our heads for a lot more than just a hat rack. Because doing something like this, it's only going to cause you more trouble in the long run, not just your twin. And yes, April, this is crazy, but hey, just because you're twins, your first instinct is protect your twin, but protecting your twin by putting yourself in that same amount of trouble, is it really worth it? Something to think about. All right, we got an update on the Karen Reed retrial, which is going to start up which has actually started up. The jury has been seated. All right, breakdown. Karen Reed standing trial for a second time on charges of second-degree murder in the death of her boyfriend, Boston police officer John O'Keefe. Reed's first trial in 2024 ended in a mistrial when the jury could not reach a unanimous verdict. Reed is charged with second-degree murder, motor vehicle manslaughter while driving under the influence, and leaving the scene of a collision causing injury or death after O'Keefe was found dead outside of a friend's house after a night out drinking in January 2022. Prosecutors say that Reed, angry with O'Keefe because he was planning to break up with her, intentionally hit and killed him with her Lexus SUV in the driveway of a friend's home after a night out drinking. But Reed's defense says she simply dropped O'Keefe off at the home and that someone inside the home attacked and killed him, leaving him in the snow. Reed's case captured worldwide attention ahead of her first trial because she has claimed that she is the victim of a widespread cover-up by local and state police to frame her for O'Keefe's death. Reed's team has not backed down from the claims and, in the months leading up to her second trial, has faced off with prosecutors in battles over experts and evidence. While many of the facts and witnesses from Reed's first trial remain the same, there are some notable differences. Michael Proctor, who was the lead investigator on the case for the Massachusetts State Police, was fired after the first trial, revealed that he had been sending inappropriate text messages about Reed to colleagues. Reed has also expanded her defense team since the first trial, which now includes Robert Alessi and a juror from her first trial, in addition to David Yannetti and Alan Jackson. The Commonwealth also changed tactics and brought in defense attorney Hank Brennan to act as a special prosecutor for the case. Both sides have also expanded their witness lists to include more experts on a variety of subjects, ranging from dog bites to accident reconstruction to the weather. And like I mentioned, jury selection began April 1st. The jury is seated. April, you said you went back and forth on that one. Well, let me break this down to you as to what I believe should have happened. And yes, for those of you who have listened to me prior to this update, I'm gonna sound like a broken record, so be prepared. In the first trial, when the jury could not come up with a unanimous verdict on certain charges, that is when the Judge Beverly Cannoni, should have taken the initiative and had the jury polled. Now, yes, it would have taken a little bit longer to get through. But with each charge, we would have had on public record as to where that jury stood. Now, there were reports that the jury was deadlocked on certain charges, but they were unanimous on that second-degree murder charge. It was a clean sweep to acquit. But like I said once before, I'm gonna also try to dig this up and in my post on the community page on YouTube, that Karen Reed's case the first time around, what they should have done was ask the jury two simple questions with each charge. What's your verdict? And is that your verdict then as it is now? That's all they had to ask. Sure, like I said, sure, it would take a little bit longer, but you would have it on public record as well. And once we knew for certain where that jury stood, we would have been able to say, okay, she's not guilty of this, or she's guilty of that, or we have a hung jury based on this or this. But apparently it didn't go that way. It didn't go that way, and now we are preparing to start up round 2 of Massachusetts versus Karen Reed. Honestly, if they had went this way before, we wouldn't be right here. We wouldn't be at this point now. That's just that. Never thought of that. I'm not busting your chops on this one, April. I'm just saying it's common sense, because normally what would happen with a jury trial, whether the verdict is guilty or not guilty, there are times when the judge will ask the prosecutor would they like to poll a jury. There are times when the judge would like to ask the defense if they would like to poll a jury. If in that moment they say yes, boom, that's where it goes. Juror number one, is this your true and honest verdict? Yes or no? That's all they would ask from juror number 1 to juror number 12. Once you get that jury polled, it's public record. And when it comes down to a mistrial or a hung jury, it only takes one. You can have 11 guilty, all it takes is one not guilty to hang it right up. Same thing flipped around. So did the defense want? So defense didn't want to, or the judge didn't ask. The judge didn't ask. She just automatically declared a mistrial the moment the jury said we're hopelessly deadlocked. We're hopelessly deadlocked. That's the key phrase they use. We are hopelessly deadlocked. But the thing is, though, you got all these charges. I mean, sure, I'm no legal. I'm just armchair quarterbacking this thing. But when it comes down to it, you have a jury of 12, a gang of 12, as I like to call them affectionately. They sit, they listen to testimony, they weigh all the evidence. But when it comes down to it, when they get to that point where it's time to render a verdict, like I said, they can have 11 guilty, 1 not guilty. That'll hang a jury, which usually means mistrial. Same way if it was 11 not guilty, 1 guilty. Same result. But when you're dealing with multiple charges, if you got first charge 12 across the board going not guilty, second charge 12 across the board not guilty, third charge a quote-unquote soft 9-3, fourth charge a soft 9-3, that's when a jury should have been polled then. Take care of the first 2 charges that the jury is totally locked in on, if they voted to acquit or did they vote to convict. Once those clear that they're unanimous, okay. Now let's get to the ones where this is soft 9-3. Same questions. What is your verdict on this charge? That's the first question. Second question. Is this your verdict then, as it is your verdict now? That's where we would know where that jury stood, and where they stand is where the judge could have said, okay, this is on these charges. I'm declaring a mistrial. Boom. That would have been right for the picking for this retrial. But instead of all the charges that she's been charged with, she could have had at least one or maybe two. If anything possible, she could have pled out on those charges too. But then again, you never know. So I have another update day coming where Karen Reed's attorneys have filed an appeal with the U.S. Supreme Court. That's coming a little bit later. Right now I'm gonna keep this thing going with the trial of Rachel Morin's accused killers is about to begin. Opening statements were started Friday in the trial of a man accused of murdering Rachel Morin while she was jogging on the Ma and Pa Heritage Trail. Victor Antonio Martinez Hernandez is facing life without the possibility of parole in the August 2023 death of 37-year-old Rachel Morin. He's facing multiple charges, watch this, multiple charges including first-degree murder and rape. A jury of 10 men and 2 women are seated. A majority of the final panel members are white and many under the age of 40. Cameras are not allowed in the courtroom. And due to the length of the trial, which is expected to last through Wednesday, April 16th, there are 6 alternates made up of 4 men and 2 women who are also selected to serve. Take you to Court TV right now for further coverage on this trial.
I will do whatever I can to keep her memory alive and to be there for her children because she's irreplaceable. She was 1 in a million.
This morning, we're shining a spotlight on the Rachel Morin murder case as jury selection kicks off today. The mother of 5 was found dead on a hiking trail in Maryland in August of 2023. It took months, but a suspect was finally arrested. Victor Martinez Hernandez, who entered the country illegally from El Salvador, was taken into custody in Tulsa, Oklahoma last June. He was charged with murder, with rape, and with kidnapping. The Department of Homeland Security says that Hernandez was expelled from the United States not once, not twice, but on 3 prior occasions. The defense made a whole bunch of last-minute requests, including jury sequestration, which was denied. Let's bring in the attorney for Rachel Morin's family, Randolph Rice. Randolph, good morning to you. How is the family holding up this morning?
Yeah, they're very nervous and obviously anxious about this, but as Patty said yesterday, you know, it's in God's hands. She understands that things happen for a reason, and she's sort of accepted the fact that God is going to take care of what's going to happen the next couple of weeks. So she's at peace with it. I know the rest of the family certainly is looking forward to opening statements on Friday.
I'm sure, Randolph. Tell me, the children, I know, of course, we want to be mindful of their privacy, but everybody wants to know, are they okay? Are they in good hands?
Well, each of them have, their fathers, they're taking care of them, and each one are grieving in a different part of the process. You've got ages ranging from 18, 19 years old down, I believe, 8 now. So they've all sort of been grieving in a different part of the process. We don't really think that they're obviously not going to be attending the trial because just of the graphic nature of the images that will be shown during this trial is something that you just can't, unsee.
Right, Randolph. Our hearts go out to them. Give them our love. I want to show you some of the proposed jury questionnaire. Geez, I'm having a hard time getting my words this morning. Yes, the proposed questions for voir dire. Randolph, I was telling my team off camera, I'm in the fog this morning. All right, so we have the jurors' knowledge of the Morin family, the use or the proximity to the Ma and Pa Trail where Rachel was killed, and donations to the Morin family's GoFundMe. We also have participation in podcasts about the case, comfort with viewing graphic evidence, and views on race and ethnicity. Randolph, your thoughts on the importance of some of these questions for those prospective jurors?
Yeah, so yesterday they had a pretrial conference where they debated between the state and the defense all of these 50 plus different questions. A lot of these were coming from the defense. They wanted to expand that voir dire, that questioning of the jury panel. And really what Judge Curtin, the Harford County Circuit Court judge who's overseeing this case, sort of shut the defense down and said, look, I'm not going to start diving into these very specific or sometimes very broad questions, because she called it essentially a fishing expedition. The defense was trying to gain more information about the jurors so they could use that in their selection process. So what she really said was that I'm going to ask a very general question. Have you heard about this case? And if so, how have you heard about it? And then I will allow you to follow up with questions of that juror to determine if they can be fair and impartial.
Randolph, thank you for that. We know that the defendant's lawyers have made the argument that there's no way he can get a fair trial. What do you say to that?
Yeah, I mean, look, there are over 200,000 potential jurors in Harford County, and I said this yesterday to the press. You know, I oftentimes will ask people, hey, have you ever heard of the Rachel Morin case? And I'm shocked how many people have not. So I think it's going to be very easy for the judge, the state, and the defense to find 12 people in Harford County who, and it's not that they haven't heard of the case, it's that they may have heard of it, but can they be fair and impartial? Can they listen to the evidence? Can they hear the witness's testimony? And can they come away with it and apply the law and find beyond a reasonable doubt is either to his guilt or innocence?
Right. Randolph, harken back to your experience as a prosecutor. You know, for many years you served in that role. Are you at all surprised that this guy is going to trial on these very bad facts?
You know, Julia, that is a great question. And early on, I thought that he might decide to take a plea. We don't know the details of what the plea was. We know there was a plea offered early on when the state was trying to prepare their case, and we certainly don't know. But there would have been an incentive there. Remember, the top count and the most serious penalty in this case is life without parole. So there's presumably was a chance of getting parole. We're not sure of that. But certainly now he's facing the possibility of life without parole. So I'm a little shocked. But at the same time, we talk about it often on the show, defendants want to take their chance to see if they can possibly get lucky and find one juror who says, you know, I just don't find enough evidence there.
All right, let me pull this information that you're requesting. April, you were asking this if it's death penalty case or not. Let's see. Cases captured national attention because of the defendant's undocumented status in connection to prior violent crimes. Police arrested Martinez Hernandez in Tulsa, Oklahoma in June 2024. Using an investigative genetic genealogy to track down family members and later matching his DNA to the crime scene. Change venues? No. Oh, no. Still digging right now. I'm trying to figure out whether... Oh, let me take it back to January 31st. If I can, that'll give me an idea. And nothing, still nothing on as far as what the penalty would be. The one piece of information I would love to give you is to whether it's life imprisonment or the death penalty as the maximum sentence for Victor Martinez Hernandez if he's found guilty. So until we know for sure, I'm sticking by my statement. If the evidence backs it, he deserves to be sentenced to life or death, depending on the situation. The situation is what the maximum penalty is. Next up, the U.S. Attorney General's office is directing prosecutors to seek the death penalty in another case, the case of Luigi Mangione. Here's what we know. U.S. Attorney General Pam Bondi said last Tuesday that she has directed prosecutors to seek the death penalty against Luigi Mangione, the man accused of gunning down United Healthcare CEO Bryan Thompson, following through on the president's campaign promise to vigorously pursue capital punishment. It is the first time the Justice Department has sought to bring the death penalty since President Donald Trump returned to office in January with a vow to resume federal executions. Bondi's decision to do so in the high-profile case against Mangione, who has drawn a following of supporters upset with the healthcare industry, underscores the Attorney General's commitment to carrying out the president's push for new death penalty cases. Trump oversaw an unprecedented run of executions at the end of his first term and has been an outspoken proponent of expanding capital punishment. Bondi's order comes after she lifted a moratorium on the federal death penalty that has been imposed under former President Joe Biden's administration. Now, let's see. Going back to the last story, is the death penalty available in that state? Let me dig. Cause I know I've got this case covered. I will check once I look this back up. And then Crumbly, Vallow, Mangione. I think wasn't this in Georgia? No, Baltimore. Okay. Is there the death penalty in Maryland? Okay, I can confirm now Maryland does not. I repeat, does not have the death penalty. Okay, so there you go, April. Maryland does not have the death penalty. So now I can go on record and saying for sure that if the evidence backs up everything, that I get how you feel about that. That if you take a life for a life. I get it. And so like I said, I'm gonna go ahead and back my statement up and say on record that if the evidence backs this case up, and Victor Martinez Hernandez is found guilty of the murder of Rachel Morin, he deserves life imprisonment, no parole. Okay, now that we got that, I'm gonna go ahead and take you back to Court TV. We're gonna hear the update on the U.S. Attorney General seeking the death penalty for Luigi Mangione.
New York. The U.S. Attorney General Pam Bondi has just announced she has directed federal prosecutors to seek the death penalty in the case against Luigi Mangione.
He, of course, is the suspect accused of gunning down United Healthcare CEO Bryan Thompson on December 4th of last year. Mangione faces separate federal and state charges. The federal charges include murder with the use of a firearm, and that carries the possibility of the death penalty. The state carries the charge of with a maximum of life in prison. But the feds are going to go for the death penalty, and we all know that Luigi Mangione has a following. People, for many reasons, I guess, have been attracted to him, and it is a very strange thing. A guy literally accused of gunning down a man on the streets of Manhattan, but is getting letters and other things with people that support him. But the United States of America apparently is not supporting him, going for the ultimate penalty.
Yeah, let's get a reaction from Franz on this one, because I even remember, just to say how extensive the coverage has been and how much it's impacted, I think even culture, that this was a recent episode I noticed of Law and Order. And you know how those kind of cases that say they're not depicting anyone that's real, but this was very clearly the Luigi Mangione case. It was a young man who killed a health insurance CEO. And at the end, when the jury was about to deliver the verdict, and throughout it had been very conflicted on people supporting him, but people being against murder, they didn't even give the verdict. They just let it go to the final credit screen. And I think that was very indicative, Franz, of people not knowing what to do with a case like this.
So most citizens don't realize that the federal government enjoys what's called dual sovereignty and the ability to prosecute along with the state without double jeopardy attaching. Now, what this does is it certainly raises the stakes of his defense in so much as he's now facing the death penalty. It's going to slow everything down, because if you're the state of New York, do you let the feds do their thing first? And that's going to take a while to do. Or do you plow forward with your prosecution, or do you say, you know what, based on what happens in the federal case, we're just going to wait and see. So I think it creates complications, but ultimately, this is a death penalty appropriate case. And if the sovereignty of New York had the death penalty, or chose, if it was a state that had it, then yeah, they probably would pursue it too. This is a cold-blooded killing. If in fact he did it, it's a cold-blooded killing that checks all the right boxes. So, I'm not shocked that the feds are going after it. And you better believe the feds probably, the DOJ consulted with the surviving victim's family and said, hey, what do you want to see happen in this? So I bet their input was probably in play at this. And look, at the end of the day, this is going to lengthen the trajectory of justice for Luigi. You cannot fast track a death penalty trial. That just doesn't happen. It's not realistic. And, I cannot blame the feds for wanting this.
Yeah, I think they had said publicly that these two trials are going to be moving along at the same track, parallel tracks. Well, guess what? This train just slowed down big time. To Franz's point, one might think now the state's going to go first. And in a case like this, with the notary, with all the ingredients, you may have a prosecutor that wants to go first. Who knows if who wants to be the lead here? But again, the breaking news: the federal government is going to pursue the death penalty against Luigi Mangione. That just announced by Pam Bondi.
Yeah, so now Ted Rowland, shout out to him, and Julia Janae of Court TV, and our good friend Franz. They're all saying the same thing, that this is now a death penalty case, and I'm wondering, like, is this for real? I mean, is Luigi Mangione, with all his supporters now, is he like the real life modern day version of John Q? And if anybody remember that movie, it stars Denzel Washington, and the same thing was going on with him going on in that movie, because he didn't have adequate health care for his son. He held a lot of hospital workers against their will. The only thing is, that was a kidnapping in the movie. This thing here with Luigi Mangione ends in murder. So now we don't know what's gonna go down next. is saying that the AG is calling this thing an act of political violence. If that's the case, then he ends up being sentenced to death because of this. Oh yeah, that was a great movie. He ends up doing time, but it was a sacrifice he was willing to pay for his son. But like I said, that ended in a kidnapping, not murder. Thank God for that. But back to Mangione, if he ends up being sentenced to death because of these actions, the only person that Luigi Mangione can blame is Luigi Mangione. So to go back to something that April said a little bit ago, that the free Luigi stuff has got to stop. I mean, there are some. You think Karen Reed has supporters? These Luigi Mangione supporters are actually wearing green, and anybody who knows their Super Mario Brothers knows that Luigi's color is green. This is nuts, guys. Absolutely nuts. All right. Next up, we have the breakdown of what Arizona versus Lori Daybell is all about. When I started it, I gave you a brief who's who in that entire case. Now here's the breakdown of what the case looks like. The jury has been seated, as you already know. Seated in the case against Lori Daybell, who is charged with conspiracy to commit first-degree murder in the death of her fourth husband, Charles Vallow. Opening statements are scheduled for tomorrow, April 7th, in Arizona. Lori is already serving a life sentence in Idaho. In 2023, she was convicted of murdering her two youngest children, J.J. Vallow and Tylee Ryan, and conspiring to kill her fifth husband's first wife, Tammy Daybell. Her husband, Chad Daybell, was convicted on the same charges and sentenced to death. In Arizona, Lori is acting as her own attorney. I'm going to stop right there just so you all can see my face. Just so you all can see my face when I say stupid move, stupid move, stupid move. Only one person was able to advocate for himself as a murder defendant and get himself acquitted on most charges and convicted on one, and was able to be sentenced to time served. Only one has done this. Lori, your chances of this happening for you, less than zero. But I digress. She's acting as her own attorney, where in addition to the conspiracy charge in Charles's death, she's accused of conspiring in an attempt to kill her niece's ex-husband, Brandon Boudreaux. The two cases will be tried separately, with the case regarding Charles's death going to trial first. Lori married Charles Vallow on February 24th of 2006 in Las Vegas. In 2013, the couple adopted J.J. Vallow from Charles's sister and her husband, Kay and Larry Woodcock, who were J.J.'s grandparents. In 2016, the couple moved to Arizona, where they settled down with Tylee and J.J. 3 years later, Charles filed for divorce, indicating he was concerned about Lori's mental health, according to the East Idaho News. Lori's older brother, Alex Cox, fatally shot Charles on July 11, 2019, while he was arguing with Lori and after picking up JJ from school. Police said during the argument, Alex claimed Charles hit him over the head with a bat. Alex told police that after he was hit in the head, he retrieved a gun from his bedroom and shot Charles in self-defense. In a probable cause statement from the Chandler Police Department, investigators said no emergency aid was provided for Charles, and he was left bleeding on the floor for approximately 43 minutes before calling 911. A grand jury indicted Lori on the charge of conspiracy to commit murder for the death of Charles. Now, let's see. Let me see how much I'm agreeing with April on this. She said Lori is ridiculous. Agreed. Already found her guilty, and then adds to the fact she's so evil. I can't disagree. I cannot disagree. After watching her in the Idaho case. After watching her reactions in the Idaho case, and then on top of it, now she's trying to defend herself in the Arizona case. This woman is trying to press her luck, and it's going to fail horribly. It's going to fail miserably. The evidence is too far stacked up against her. Whatever evidence they add from the Charles Vallow case, it's just going to be stacked on everything they already got for the killings of J.J. Vallow and Tylee Ryan and Tammy Daybell. I'm surprised that the jury in Idaho was able to come up with a sentence of life in prison without parole. But like I said earlier, she's defending herself. And the quote that I wanted to use is one of the oldest quotes when it comes to legal stuff. He or she in this case, who represents him or herself in court, has a fool for a client. April's chimes right in and watch this. And she says that Lori Vallow loves the attention. She thinks she's so smart. Can anyone say Sarah Boone? If you remember that this comment could have actually went right directly to Sarah Boone, and they both be right. But here's the thing about Sarah Boone's case, though. Like Lori Vallow, Sarah Boone was found guilty of murder too. How smart was that? That's all I'm saying. Next up, let me flash you back real quick. The defense team for Jennifer Crumbley. Jennifer Crumbley is the mother of the Oxford school shooter back some years ago. Jennifer Crumbley, along with her husband, both were found guilty and sentenced to 10 years for their actions or lack thereof in stopping their son, Ethan Crumbley, from shooting up the high school in Oxford, Michigan. Oxford High School in Michigan. So now Jennifer wants the prosecutor removed from the case. To which the judge said, like an NBA jam, "Get that shiitake mushroom out of here." Literally, the judge finds no jurisdiction to remove the prosecutor from Jennifer Crumbley's case. Here's the breakdown out of Michigan. An Oakland County judge has ruled that her court does not have the jurisdiction to decide a motion brought by attorneys for Jennifer Crumbley to disqualify the Oakland County Prosecutor's Office from her case. In addition, Judge Cheryl A. Matthews found the motion itself was brought for an improper purpose and ordered Crumbley's attorney be sanctioned for bringing it. Attorney Michael Desi filed the motion in Oakland County Court stating that McDonald cannot be trusted to prosecute this case consistent with the constitutional, legal, and ethical duties imposed upon her office. Judge Matthews also ordered that Desi will not be reimbursed the cost of filing the motion, since she did not have the jurisdiction to decide it because Crumbley has filed an appeal of her conviction. Crumbley was convicted on 4 counts of involuntary manslaughter connected to the deadly Oxford High School shooting in November 2021. Her son was the shooter who killed 4 students: Hannah St. Juliana, Justin Schilling, Tate Meyer, and Madison Baldwin. Her husband, James Crumbley, was convicted on the same charges. Well, time to go right back to the drawing board, or just go ahead and give that up entirely, because honestly, like I said, your lack of actions is what caused that shooting, Jennifer Crumbley. James is sitting behind bars right now, doing his time. My suggestion, go ahead and do yours too. Get it over with. You at least you two will be behind bars for 10 years. Your son, however, is in there for life because of the damage he did. When I say damage, I'm not just talking about the 4 people he killed. I'm talking about the many more that he injured in that shooting. Something you need to think about. Next up, the question of whether DNA evidence should be admissible in the trial of Rex Heuermann. In my opinion, yes. Why not? It's been admissible in murder cases before. Why not? Why not this one? What's special that it shouldn't? Let's dig. Out of Riverhead, New York, the question of whether certain DNA evidence can be used in the upcoming trial of a Manhattan architect charged in a string of deaths known as the Gilgo Beach killings is the focus of court hearings that began this past Friday on Long Island. Lawyers for Rex Heuermann want DNA tests conducted by the Astria Forensics on hairs recovered from most of the 7 victims in the case to be excluded from trial, saying the California-based lab's method has never been accepted in a New York court of law. But an academic expert testifying in the pre-trial hearing on that Friday in Riverhead Court said the type of testing used, known as nuclear DNA or whole genome sequencing, is widely accepted in the scientific community. Dr. Kelly Harris, a University of Washington professor of genome sciences, described Astria Forensics' method as an elegant and powerful way to determine whether hair fragments pulled from a crime scene match those taken from suspects. Heuermann's attorney Michael Brown sought to temper Harris's testimony, noting during his cross-examination that she had no background in the forensic science used in criminal cases. He also pressed Harris on her close ties to the co-founder of Astria Forensics, Dr. Richard Green, who she has co-authored research papers with and considers a colleague. She's the witness for hire, and she was suggested by Dr. Green to be a proponent of this magic, as we call it, Brown said after the day-long hearing. He also took aim at Astria Forensics' use of the publicly accessible 1,000 Genomes project, which sequenced the DNA of some 2,500 people worldwide as the reference pool for comparing hair samples in the case. Hopefully the point got across that it has no business being utilized in criminal court, Brown said outside of court. The 1,000 Genomes project has been around for quite a while, and it's never been used in a forensic setting. And the reason they don't use it as a population reference is simply not enough people to compare it to. The proceedings continue this coming Wednesday, when other experts are expected to testify before Judge Timothy Mazzei renders a decision. Huerman, who was dressed in a dark suit, didn't speak during the hearing. Asa Ellerup, who reached a divorce settlement with Huerman on Thursday, on that Thursday, was also in court, along with the couple's daughter and the family's lawyer. No trial date has been set for the case, which spans decades of killings on Long Island. Huerman's legal team also wants to break the case into multiple trials over concerns about the cumulative effect of the evidence presented by prosecutors. Suffolk County District Attorney Ray Tierney's office has opposed that request. Mazzei is expected to rule on that soon. Prosecutors argued in legal briefs ahead of the hearing that the whole genome sequencing has been accepted in peer-reviewed scientific journals and by federal regulators, paleontologists, viralists, and medical communities. They say the findings by Astria Forensics were also independently corroborated by another lab's mitochondrial DNA testing, a methodology long accepted by New York courts. Since late 2010, police on Long Island have been investigating the deaths of at least 10 people, mostly female sex workers, whose remains were discovered along an isolated highway not far from Gilgo Beach. Huerman, who lives in nearby Massapequa Park, was arrested in 2023 and charged in the deaths of 3 of the victims between 2009 and 2010: Melissa Barthelemy, Amberlyn Costello, and Megan Waterman. While in custody, he was subsequently charged in the deaths of 4 other women: Valerie Mack in 2000, Jessica Taylor in 2003, Maureen Brainerd Barnes in 2007, and Sandra Costilla in 1993. Huerman has maintained his innocence and pleaded not guilty to all counts. So the question of whether oh, you have to take the dog for a quick walk. Okay, I'll try to be here as long as possible to get all this information out. So getting back to the main question as far as the DNA evidence, should it be admissible? Again, I say yes. If it can bring to a conclusion and a definitive verdict in Rex Huerman's case, then why not? If it's been used many times before, then again, it should very well be used. Okay, next up on the docket, a pregnant mother was found bludgeoned to death in a shopping cart, and the search of the man's home revealed a horrific scene. Ooh boy! All right, guys, take a good look here. This is the murder victim, Brittany Hopkins. A pregnant woman was killed in February and found wrapped in a blood-soaked comforter and stuffed inside a shopping cart, according to newly released court documents. 38-year-old Brittany Hopkins was found dead on February 28 in a residential area of Cedar Rapids, Iowa, by officers responding to a report of a deceased person. That's according to the Cedar Rapids Police Department. On March 19th, Donnie Dannell White was arrested in Nevada on a murder charge regarding a homicide in Cedar Rapids, according to a statement from the U.S. Marshals, the agency that made the arrest. White was arrested in connection with Hopkins' murder, according to a spokesman for the Cedar Rapids Police Department. Online court records show the alleged murder took place on February 26th. The 51-year-old White is accused of beating Hopkins to death, covering her body in a comforter, and putting her in a shopping cart, according to a newly released criminal complaint cited by CBS 2 Iowa, KCRG, and the Gazette. Hopkins was pregnant at the time she was killed, according to Cedar Rapids police. The comforter she was wrapped in was soaked with blood and had been tied with tape, according to the complaint. Her body was underneath several bags of garbage. This is our defendant, Donnie Donnell White. Police say after they released information about Hopkins, they were tipped off about White, who was reportedly seen with the slain woman the day before her body was found. Again, this is according to the Gazette, KCRG, and CBS 2 Iowa. One witness told police they had seen White and Hopkins on February 26th, and he had assaulted the woman in front of the witness, according to the complaint. Security footage reviewed during the investigation Hopkins and White in the parking lot of a storage facility on February 22nd. During a search of White's residence, police found a bloodied scene including blood splatter on the wall, bleach stains on the carpet resembling the outline of a human body, and a hammer that had hair and blood on it, according to the complaint. In an online fundraiser, Hopkins' family says she was the mother of 3 children ages 14, 4, and a toddler just shy of 2 years old. They now have to learn to live without the woman that provided them life, her mother wrote, adding that Hopkins had been fearing for her life. They further alleged Hopkins may have fallen victim to human trafficking. Cedar Rapids declined to comment on these claims, citing the pending investigation. It wasn't immediately clear how White may have known the victim. He has been charged with first-degree murder and non-consensual termination of pregnancy, according to online court records, which do not indicate a plea or attorney information. So we'll have to wait and find out what's really going on with that particular case, and when I get that update, you'll get it here. Now we're about to go back to North Carolina. According to a police report, a North Carolina man was released from prison, and then a week later, he fatally shot his mother and brother. Here's your victims here. On your left is Dana Jenkins, and on your right, Darren Cox. A North Carolina man allegedly killed his mother and teenage brother 1 week after he was released from prison, according to multiple news outlets, which cite authorities and court records. 25-year-old Daron Jenkins has been charged with 2 counts of first-degree murder in connection with the double homicide in a home in Wilson, North Carolina, which took place on Monday, March 31st. That's according to police. Police statement to ABC 11, shout out to them, WITN TV, and CBS 17. Officers responded to the home just before 5:30 p.m. that day, where they found the bodies of 50-year-old Dana Jenkins and her 15-year-old son, Darren Cox. Again, that's according to ABC 11 and WBTV reports. Police confirmed to ABC 11 that the woman is the suspect's mother and the boy is his brother. Further details regarding the circumstances of the deaths is unclear and remains under investigation by police, according to the outlet. Also, according to court documents cited by ABC 11 and WITN TV, Daron was released from prison on a separate crime 1 week before the killings. And this is the suspect, Daron Dante Jenkins. Janilla Corngay, Dana's cousin, described the mother as a very sweet person who always smiled for ABC 11. She added that her death comes as a shock. I never would have thought that, Corngay told the outlet. I would have never thought he would do something like that. Daron is being held at the Wilson County Jail on no bond, according to CBS 17, citing the arrest records. It's unclear if he has entered a plea or retained an attorney to speak on his behalf. People magazine has contacted the Wilson Police Department for a comment on the case, but they did not hear back in time for the publication. Now, what in God's name would provoke someone just a week after being released from prison, to shoot his mother and brother dead. I hope they come up with some kind of an update regarding motive, because even this, I'll say it's strange, but in these days you never really know. You never really know. Next up, a mother and daughter were again another shooting. A mother and daughter were fatally shot near a California school while waiting at a stoplight. To come out and see a mother and daughter, it's really heartbreaking, one neighbor tells. A mother and daughter were fatally shot as they sat in a vehicle together near a California school, according to authorities. The two victims' names were withheld, but on Wednesday, April 2nd, Los Angeles County Sheriff's Department Lieutenant DeJong identified the deceased as a 45-year-old woman and her 22-year-old daughter, according to a press release. Deputies from the Compton Sheriff's Station were dispatched just after 7 p.m. on Tuesday, April 1st, to the intersection of Caldwell Street and Central Avenue near Caldwell Street Elementary School. Authorities arrived to find the two women dead, suffering from multiple gunshot wounds. Their Toyota sedan had crashed onto the sidewalk near a traffic pole. One woman's body was discovered in the street, while the other body was still in the car. Investigators learned the victims were in their vehicle on Caldwell Street, stopped at the signal light when a vehicle pulled alongside, according to the press release. Investigators believe the occupant in the other vehicle opened fire on the victims. The suspect fled the scene southbound on Central Avenue, the LA County Sheriff's Department added. Footage from local news stations KTLA and NBC Los Angeles showed crowds later gathering, observing the car, which had a white sheet covering the windshield area. Neighbor Debbie Shaw spoke with NBC Los Angeles about the fatal shooting after talking to the 22-year-old's boyfriend. She did just pick up her mother from work, she told the news station. To come out here and see a mother and daughter, that's really heartbreaking. Deidre Culpepper, who also lives in the area, added, "It's devastation. Compton is heartbroken right now." The Los Angeles County Sheriff's Department said there are no additional details available at this time. So now we're looking to you. If there's anyone with information about this incident, you are encouraged to contact the LA County Sheriff's Department's Homicide Bureau. That number is 323-890-5500. 323-890-5500. If you prefer to provide information anonymously, you may call Crime Stoppers by dialing 1-800-222-TIPS, 1-800-222-8477, or use your smartphone by downloading the P3 TIPS mobile app on Google Play or the Apple App Store, or by using the website lacrimestoppers.org. I would love to get a little more information on this case, and when we get it, we'll be sure to give you all the details, because this is a sad scene that has come across California. All right, next up, we're back to the Karen Reed case. We're on the road to the retrial, and we're gonna drop six of the biggest bombshells in that case. So here we go. Nearly a year after the mistrial, in her first murder trial, Karen Reed is standing trial for a second time on the same charges. The last 9 months have been filled with explosive revelations and developments in the case that have the potential to make the second trial starkly different from the first. As we mentioned earlier, Reed's first trial ended when Judge Beverly Cannoni declared a mistrial on July 1st, 2024. Reed is accused of murdering her boyfriend, Boston police officer John O'Keefe, maintained during the initial trial that she was a victim of a botched police investigation and was being framed for O'Keefe's death. The trial featured many big moments, with lead investigator Michael Proctor forced to read inappropriate text messages he had sent about the defendant, and the defense's revelation that video of Reed's car in the police department's Sally Port appeared reversed. So let's go ahead and drop these bombshells. First, jurors come forward. Days after the mistrial, several people who said they served as jurors approached both Reed's defense team and prosecutors to say the panel had in fact unanimously to acquit Reed on 2 of the charges, second-degree murder and leaving the scene of a deadly accident. Unfortunately, at that time, we did not fill out any of the paperwork there nor sign it. Juror Ronnie Estanislao told Court TV. He said the panel did not understand that they could consider each charge separately and return verdicts on only the 2 counts. Reed's defense argued that before Judge Cannoni, the Massachusetts Supreme Judicial Court, and a federal judge, that the 2 charges should be dismissed, but was unsuccessful. Days before the jury selection for the Reed trial began on April 1st, Victoria Judge, a non-deliberating juror from Reed's first trial, joined her defense team as an attorney. Next, why 2 jurors were dismissed from the first trial. In a written ruling addressing the defense's allegations of governmental misconduct, Judge Cannoni revealed why 2 jurors were removed from the first trial before deliberations began. Juror A reported to officials that Juror B had made comments about Rachel's facial expressions and demeanor, though no other jurors reported hearing Juror B's comment, only Juror A's report. Juror B was dismissed. Juror A was later dismissed after a report that they had been recorded talking about the case while under the influence of alcohol at an American Legion post. Next up, the new details from January 2022. John O'Keefe was found in the early morning hours of January 29th, 2022, and in the years since the first trial. New details have emerged about the first minutes and hours of the investigation. In an interview for a documentary, Reed gave new details about finding her boyfriend in the snow, telling a reporter that she removed a piece of glass from his face. A detail prosecutors said they had never heard before. In evidentiary and motions hearings ahead of the retrial, Reed's defense also said they continued to receive new evidence and videos from the day O'Keefe was found. Among the evidence is a new piece of video showing Bryan Higgins at the Canton Police Department. Higgins, who shared a kiss with Reed and whom the defense has pointed to as a potential third-party culprit in the case, has previously denied going to the police department that morning. Next, Michael Proctor, you're fired. The inappropriate messages Proctor sent over O'Keefe's death led to awkward moments for him on the stand as he tried to defend his investigation into the murder. But the messages had far-reaching impact and soon had attorneys in other cases he'd investigated, such as that of Brian Walsh asking to look through his records. Proctor was called to appear 3 times before a police trial review board, which ultimately recommended he be dismissed from the Massachusetts State Police. He is formally dismissed on March 19th. The federal investigation was closed next. Proctor's behavior figured into a federal investigation that focused on the police work in the Reed case. While federal investigators were tight-lipped about the specifics of their investigation, Special Prosecutor Hank Brennan announced at a hearing in early March that federal agents had closed their case. Despite confirming the change in the status of the investigation, Brennan did not reveal anything gleaned from the investigation, but said that no charges were filed. And finally, ARCCA witnesses were paid. Two expert witnesses in the area of crash reconstruction who testified for the defense in the first trial, Daniel Wolf and Andrew Rentschler, presented themselves as impartial to the jury. Wolf and Rentschler worked for ARCCA and were hired by the Department of Justice as part of the federal investigation into the case. However, with weeks to go before the retrial, Brennan revealed in court that the experts had submitted an invoice to the defense for $23,000 dated July 12th, 11 days after the mistrial. Brennan accused the defense of deliberately lying to the court and wanted the experts barred from testifying at the retrial. Judge Cannoni allowed Wolf and Rentschler to return, but the defense will not be allowed to present them as unbiased experts. So now that you know everything that's going to go down, everything that has happened since the first trial, now you're a little bit more prepared for Massachusetts versus Reed 2. Next, it's sentencing for the forgetful grandmother trial, Florida versus Tracy Nix. A Florida grandmother whose granddaughter died after being left in a hot car. Here we go again. Florida grandmother whose granddaughter died after being left in a hot car was sentenced to 5 years in prison. 67-year-old Tracy Nix was charged with aggravated manslaughter in the November 2022 death of Uriel Schock. In January, a jury found her not guilty of that charge, but convicted her of leaving a child in a motor vehicle in excess of 15 minutes. See, this is what I'm talking about. When handing down Nix's sentence, the judge noted her lack of remorse, saying she showed sorrow. As proceedings ended, the judge also said he was adjudicating her guilty for the record. The day Uriel died, Nix told the detective after she drove home from lunch with friends she just forgot about the baby in the back seat of her Lexus SUV. It wasn't until one of her grandsons arrived that all of a sudden it came across her head that Uriel had been in the SUV all afternoon. Temperatures that day reached 90 degrees Fahrenheit. A medical examiner determined Uriel died from hyperthermia as a result of being left in a hot car for several hours. And according to Scripps News Tampa, Uriel is the second grandchild to die under Nix's care. In 2021, 16-month-old Ezra Schock drowned in a nearby pond after Nix fell asleep. A judge ruled Ezra's death could not be mentioned during the trial for Uriel's death. And this is what I refer to every time I do this. Right around Memorial Day, I sit right here and I do these PSAs to get you more than prepared that summer's coming, the weather's getting warmer, and the last thing you want to do is become a defendant because you left your child or grandchild, niece, nephew, or whatever in a hot car. One second, guys. No, we haven't started yet. The summer hasn't even got around yet, sweetheart. Ladies and gentlemen, the voice you may hear in the background is my wife, Lady Outlaw. Um, Basically, honey, what I'm covering right now is the sentencing of 67-year-old Tracy Nix, who left her granddaughter in the back seat of her Lexus SUV, with the temperatures outside hitting 90 degrees and up. Yeah. So it's not let me go back real quick. She was charged with aggravated manslaughter, but she was convicted of leaving her child in a motor vehicle in excess of 15 minutes. The penalty, 5 years in prison. Yep. So I guess my wife I had more than enough of that one. But like I said, every summer I say the same thing every time. If you don't want to become a defendant, beware of your surroundings, beware of the weather report, because the weather is getting warmer. The weather is going to get warm. And I'm going to do the same thing this summer, right around Memorial Day. So come back here, Bethea'S Byte Reloaded right around that time. I guarantee you, I will be saying those same words. You do not want to leave a child or a pet in a hot car. The chances of you doing that will lead you right in the courtroom as a defendant. Watch my words. Next up, a convicted killer who I keep saying may have the coolest name for a defendant was doing court on charges she attacked a prison guard. Oh boy. Then during the hearing, she was tackled in court after a violent outburst. Convicted killer Taylor Shabiznis. You like that name, Shabiznis? Taylor Shabiznis was tackled by officers moments after her preliminary hearing was called to order on Friday morning. Shabiznis is serving a life sentence at Taycheedah Correctional Institution after she was convicted of murdering Shad Therion during a drug-fueled sexual encounter. While behind bars serving her sentence, Shabiznis got in trouble again for allegedly attacking an employee of the prison where she is being held. As the attorneys entered their appearances, Shabiznis leapt up from her seat and began yelling as she lunged toward her attorney, Curtis Jolka. The guards who had been standing near her immediately tackled her to the ground and removed her from the courtroom. The hearing resumed a short while later with Shabiznis participating via Zoom. Judge Anthony Niels said he found she had waived her right to be present due to her behavior. Jolka asked the judge to withdraw from the case, citing the attack. Judge Niels said he could withdraw following the hearing, which then proceeded. Appearing on a screen in the courtroom, Shabiznis' brow was furrowed and her arms appeared to be restrained to the chair in which she was sitting. A criminal complaint reviewed by Court TV alleges that Shabiznis requested medical attention for a staple in her arm on July 24, 2024. While a nurse went to get tweezers to help her, Shabiznis allegedly lunged at the nurse. A prison guard intervened, allowing the nurse to escape, but Shabiznis then attacked the guard, hitting her in the head with a tray and swinging a metal table at her. On Friday, Detective Christina Malin testified to the incident, during which she had said witnesses described the defendant as laughing. Judge Niels found probable cause for the case to move forward to trial. Shabiznis pleaded not guilty and, following the hearing, was assigned a new attorney. Information reviewed by Court TV indicates that Christopher Froelich is Shabiznis' new attorney. He previously represented her during her murder trial. If I remember right, he was the very same attorney who was attacked by Shabusiness while she was being sentenced for the murder of Therian. Now he's back for round 2. All I can say is, good luck, buddy. You're gonna need it. Next up, a judge is declining to send Young Thug to prison over a viral post that he made. This is an interesting thought. A judge in Atlanta has declined prosecutors' request to revoke Young Thug's probation and send him to prison. But the judge cautioned him over his social media use after his viral post sparked an online backlash against the district attorney's office. The Grammy Award-winning rapper pleaded guilty in October to gang, drug, and gun charges and was released from jail. Fulton County District Attorney Fannie Willis said in a court filing Wednesday that he engaged in conduct that directly threatens the safety of witnesses and prosecutors, compromises ongoing legal proceedings, and warrants immediately revocation of probation. Fulton County Superior Court Judge Paige Reese Whitaker said in an order on Thursday that she had reviewed Willis's filing and a response by Young Thug's attorney and declined to revoke his probation. While the court does not find that the cited social media posts rises to the level of violation of defendant's probation, it may be prudent for the defendant to exercise restraint regarding certain topics, Whitaker added in a footnote to her one-paragraph order. Willis said Young Thug reposted a social media post that included a photo of an investigator in the district attorney's office with a caption that said the investigator is, quote, the biggest liar in the DA's office, end quote. The post quickly went viral, amassing over 2 million views with thousands of comments and retweets. The investigator's home address and that of her parents were posted publicly, and some posts included threats to the investigator and her family, the filing says. One post threatened the assassination of Willis. I don't make threats to people. I'm a good person, Young Thug posted Wednesday night on the social platform X, formerly known as Twitter. I would never condone anyone threatening anyone or definitely participate in threatening anyone. I'm all about peace and love, end quote. Bryan Steele, an attorney for Young Thug, said in a court filing Thursday that prosecutors' allegations were misleading and that the rapper hadn't done anything to violate his probation. Young Thug, whose given name is Jeffrey Williams, was indicted along with more than 24 other people in May 2022, accused of violating Georgia's anti-racketeering law. The indictment said the rapper co-founded a violent street gang that committed multiple murders, shootings, and carjackings over roughly a decade and promoted its activities in songs and on social media. Whitaker gave him a total sentence of 40 years. The first 5 years were to be served in prison, but that was commuted to time served. Then he has 15 years on probation. Finally, a backloaded 20 years in prison will be commuted to time served if he complies with all of the conditions of his probation. If the judge had granted the probation revocation, that 20-year prison sentence would have taken effect. Prosecutors said the investigation photo Young Thug reposted is currently a witness in a multi-defendant gang murder case. A judge explicitly said during a hearing that the investigator was not to be shown on television while testifying, the filing says. A blogger posted the investigator's photo on social media with the caption, "She doesn't want to be shown on screen? Well, here she is." And Young Thug reposted that, prosecutors wrote. Young Thug's continued association with individuals actively involved in witness intimidation, threats of violence, and obstruction of justice is a violation of the conditions of his probation, prosecutors wrote. His lawyer wrote that there's no suggestion the rapper was aware of the judge's order not to show the investigator, and it's not a probation violation to repost an image on social media with an opinion that the investigation is untruthful. None of the direct threats cited by prosecutors are attributed to Young Thug. The trial for Young Thug and 5 others began in November 2023 after it took nearly 10 months to see the jury. The rapper and 3 other defendants pleaded guilty in October. A jury in November found the 2 remaining defendants in the trial not guilty of racketeering, murder, and gang-related charges, although one of them was convicted on a gun charge. Young Thug co-wrote the hit This Is America with Childish Gambino, which became the first hip-hop track to win Song of the Year Grammy in 2019. If I were Young Thug, I'd be careful of everything I post and repost on X, because posting the wrong thing at the wrong given time could put him right behind bars. Next up, a former U.S. attorney is joining the prosecution team in the case against Bryan Kohberger. Idaho's former U.S. attorney has joined the prosecution team in the case against Bryan Kohberger, the man accused of killing 4 University of Idaho students in November 2022. Joshua D. Hurwitz will serve as the special deputy prosecuting attorney for Latah County, according to a recent court filing. Latah County prosecuting attorney Bill Thompson is still leading the prosecution team. Hurwitz, who was appointed by former President Joe Biden in 2022, left the state's top federal law enforcement position in February 2025 at the beginning of the new presidential administration. Kohberger is charged in the deaths of Kaylee Consalves, Madison Mogan, Xander Kernodle, and Ethan Chapin, whose bodies were found in an off-campus rental home. His trial is scheduled to begin August 11th in Ada County. Prosecutors intend to seek the death penalty if he's convicted. In a separate filing, prosecutors said the defense has not fully disclosed the data behind 2 mental health evaluations of Kohberger. The state requested additional materials, including test results and the facts supporting the experts' conclusions, to allow their own experts time to review and prepare a rebuttal. The supplemental discovery request specifically refers to evaluations by forensic psychiatrist Dr. Eileen Ryan and neuropsychologist Rachel Orr. Kohberger's defense says their client has autism spectrum disorder and a coordination disorder that may explain how he appears in court. The argument is expected to be discussed at a hearing April 9th, which is Wednesday, and I'll be sure to update that in the community post whenever I get that information. Next, a Texas teen has been charged with murdering a 17-year-old at a high school track meet. And I'll start with this first. A 17-year-old student was fatally stabbed by another student during an altercation at a high school track meet in suburban Dallas on Wednesday, according to police. The suspect, 17-year-old Carmelo Anthony, no basketball fans, not that Carmelo Anthony. Carmelo Anthony was taken into custody and charged with murder, according to police in Frisco, about 30 miles north of Dallas. Bond had not been set. A police spokesperson said Anthony was being held at the city jail and would be transferred to Collin County Jail. The spokesperson also said he did not know whether Anthony had an attorney yet. Efforts to find contact information from family members to speak on Anthony's behalf were not immediately successful. So now we're going to go right to Court TV for coverage in this case. Carmelo Anthony charged with murdering a 17-year-old at a high school track meet.
All right, many of us saw that viral track meet moment. Now there's another one with much more dire circumstances. The family of a boy who was stabbed to death at a Texas track meet is speaking out against what they're calling a senseless incident. Boy, is it ever. 17-year-old Carmelo Anthony, spelled with a K, was charged with first-degree murder. Police say he stabbed Austin Metcalf after an altercation during a high school track meet just north of Dallas. The twin brother of 17-year-old the victim here tried to save his brother, but the Metcalfs say Austin died in his twin brother's arms at the track meet. The surviving brother and mother spoke to ABC.
I tried to whip around as fast as I could, but I didn't see the stab. But then I looked at my brother, and then I'm not going to talk about the rest. So that's just what I saw, and I tried to help him.
He's the most amazing kid. Oh, so smart. He had college football guys looking at him to play in college just because the kid was mad my son is not here anymore, and I don't understand it.
Yeah, we're asking, well, what can be learned from this? Nothing. It's an unprecedented stabbing according to the school district. It's a just difficult case all the way around. Let's bring in our guests. Criminal defense attorney, former prosecutor David Bruno still with us. Joe Tamburino is with us, and retired NYPD detective Mike Alcazar also joining the conversation. Joe, this is one of those just head shakers. There's really nothing you can say. There seems to be ample evidence against this young man, and of course these are allegations now. But your overall thoughts about this disturbing case?
Good morning, Ted. Thank you for having me on. Yes, it's extremely tragic. And I think some of the initial statements by the victim's family ring true. I mean, this person, Carmelo, why was he bringing a knife to a football game? Why are you bringing a knife to sit in the bleachers, to watch a football game, enjoy yourself? I mean, what was going on with this person? And I think it's another example of people just resorting to violence first, rather than trying to discuss differences. But I think the victims' families, they're asking the right question, which is, what is going on with this individual who's accused of murdering the young man?
Mike, you've seen a lot in your days with NYPD. Are things getting worse, or are we just hearing about these type of crimes more often and through social media, et cetera?
I mean, I hope it's not getting worse. I've seen lots of cases like this. I have a similar case that investigated happened where two young men collided and one had a knife. So the problem is that when people bring weapons to like an event like this, or just carry a weapon, there's no cooling off period. So yeah, words are not enough, and it's a crime of passion. And unfortunately, this young man died because of this. And you know, it reminds me of my grandson, who also plays football, around the same age. And I always tell him, be careful who you're having an argument with or you're having a fight with. You never know what they're carrying, unfortunately. So I really feel for the family. It's very close to home when something like this happens.
Yeah, I mean, this was a track meet. He was a football player as well at a 4.0. David, on the other side of things, the defendant to be here is a young man, had that weapon, but also probably had a mind that couldn't deal with whatever was happening there, the beef, I guess, that he had. As a defense attorney, how would you approach defending this young man?
Well, first question in the legal system is going to be, is he going to be treated as a juvenile or an adult? The accused is 17 years old, so that starts in juvenile court, and prosecutors are going to have to evaluate whether or not to treat him as an adult. So as a defense attorney, you want to come in and provide a background, mitigation. Maybe he's got treatment records, mental health issues. What's the family situation? Has the Child Protection Services been involved in this family's life? There are a number of things that could be done to look at background to try to keep it in the juvenile system versus the adult system. And I'm with Joe. Why in the world is a student having a knife at a track meet? I mean, this was 10 o'clock in the morning at a track meet where there was an altercation. And certainly if he has a weapon at a place he's not supposed to, he's not going to be able to use self-defense as the aggressor either. So those are some initial legal issues that I've identified.
Yeah, absolutely. It's a very difficult one because both of them, one is dead, as you heard from the mom. I mean, sounded like a wonderful kid, and then the other 17-year-old is likely going to be spending most of his days in prison if indeed he's found guilty.
Such a tragic story, and I'm looking to get more details on this as the investigation progresses. But as for the family and friends of the victim, I pray for peace that surpasses all understanding. I pray that you will get the justice that you're seeking for Austin Metcalf. And as for Carmelo Anthony, I pray that I'm praying that he receives the justice due to him, because who and why would you put yourself in a position bringing a weapon to a track meet and then killing someone else just because you could? You're making no sense, bruh. You're making no kind of sense. Speaking of things that don't make any sense, next up, the attorney for a woman accused of holding her stepson captive says, you ready for this, guys? This didn't happen. I mean, what? I'm not trying to make light of this, but I gotta ask the question: is Kimberly Sullivan's defense team using what I like to call the Shaggy / Rick Rock defense? What do I mean by the Shaggy and Rick Rock defense? You remember, if you ought to know the song by now. Well, she caught me on the counter. It wasn't me. I'll just leave the rest alone. Here's part of the breakdown. Now, then we're gonna go to Court TV. The attorney for a woman whose stepson claims he was held captive at their home for decades says there has been a rush to judgment and maintain his client is innocent of any crime. 56-year-old Kimberly Sullivan is charged with assault, kidnapping, unlawful restraint, cruelty, and reckless endangerment after her stepson set fire to their home and told police he did so to escape captivity. While the alleged victim, age 32, told officers that he was restrained in the house for 20 years, Sullivan's attorney says the claims are false. My client denies having done anything wrong, Sullivan's attorney Ioannis Kalodius told Court TV's Vinnie Politan. The defense will be that this didn't happen. The details will come out, but our defense is that she did not commit this offense. So, I am going to get you more give you more on this this segment on Vinnie Politan Investigates from Court TV. So I now leave you in the hands of my main man, 50 Grand, the one and only Vinnie Politan.
What is Kimberly Sullivan's defense? What is she going to say? Like, will there be an explanation? Will there be a defense to the allegations here? Well, there's one really good way to find this out, and we're going to do it right now. Here with us, the attorney for Kimberly Sullivan, joining us, Ioannis Kalaitis. Ioannis, thanks so much for joining us. I really do appreciate it. I know you're a busy guy, and you came down to the studio in New York tonight, so we appreciate that. So let's talk about the defense. What is the defense going to be about in this case?
Well, good evening, Vinny, and thank you for having me. I appreciate the opportunity. So everyone's asking what the defense is going to be in this case, and to some extent it's premature to get into specifics and details about everything that we are going to allege or what we're going to present at trial. We're still getting the discovery in this case. We're still sorting through exactly all the details about the allegation and finding out more about the state's case. What I can tell you is my client denies having done anything wrong. The defense will be that this didn't happen. The details will come out. But our defense is that she did not commit this offense.
So, and I appreciate it. I'm an attorney too, and I know your obligations in representing someone and how that works. So, what role will the father, the biological father of this 32-year-old man, play in the defense? And how much do you suspect the jury will find out about the father? And how much do you know about his role in everything that transpired over the course of decades, is what the allegations are?
So we are going to get into that. We are still sifting through a lot of that information. What I can tell you is that the father is the one that dictated how his son would be raised. This was not my client's biological son. She did not make the determination as to schooling, being pulled out of school. A lot has been put on her, and that is simply not the case. We anticipate the evidence that will come out at trial will show that he is the one that made the decisions for his son.
Was she at all concerned about the health of this 32-year-old? And just going from the arrest affidavit, right, hasn't been cross-examined, I understand, but the appearance, just the physical appearance of a 32-year-old man being 68 pounds, teeth are all rotted out, the hair is matted, all of that. Did she have any concern about his health, his well-being?
I believe she did. But one thing I want to point out, he's 32 years old. She could not control whether he took care of himself properly or not. He was 32 years old. What I can tell you is she denies ever restraining him. She denies ever locking him in a room. She denies ever depriving him of any of these opportunities.
Do we know, and obviously your client lived in the house the whole time, I presume, right, with the father, her husband. At any point during the course of his life, not in the last year since the father passed away, but when the father was still in the house, did he restrain his son? Did he deprive his son of food? Because another one of the allegations was that this child, when he was a child, 2 decades ago, he was always hungry.
My understanding is there was always food in the house. There was no restrictions on the ability to get food in the house. And I know you asked about earlier, but what I can tell you, when the police went in that home, there was food in the cupboards, there was food in the refrigerator. My understanding is he had access to this.
And let's talk about the victim in the case, the 32-year-old, or the alleged victim, obviously, as to your client. I would still say he's a victim of his father as a child being pulled out of school and then not educated. What are your... Is he not telling the truth? Do you believe that he is making allegations that are false, like he himself, not the prosecutor, but statements that he's making to investigators and to police are factually inaccurate about what was taking place in the last year?
Well, look, I don't want to come on here and bash this individual, but what I can tell you, based on the discovery I have seen, the interviews I have watched, there will be significant credibility issues. This case ultimately is going to come down to credibility. There is no independent smoking gun. There's no video, there's no admissions. It will be one person's word against another's, potentially.
And what was the nature of their relationship after the father passed away? How would you describe this stepmother, child, who's an adult, obviously, but what was their relationship like? Because they're living in the same house.
I don't have specifics as to their relationship. Nothing that has been indicated to me indicates that it was a hostile relationship in any way. They both lived in the home. I'm unaware of any significant problems between them while in the home.
Okay, Ionis is going to stay with us. He's been gracious enough to stay for 2 segments. We appreciate that. Coming up next, why was his biological mother not in his life?
That's it. I have 2 cats.
Everybody's out?
Yes.
But your stepson's still inside?
Yeah.
To stop it right there, guys. Had to stop it right there because is he kidding me? You have a young man who's allegedly held captive for 20 years, since the age of 12, by his stepmother, and the attorney is saying on behalf of his client that it never happened? Like a Phillies fan on TikTok would say, "Are you kidding me? Are you kidding me? What kind of defense is that?" It wasn't me. I didn't do it. This never happened. Come on now. Now even he as an attorney should know better than that. Anyway, let's go ahead and continue.
Lori Daybell.
Already convicted for murders of her children.
Doomsday cult mom is now lawyer Lori.
She's representing herself.
On charges of conspiring to murder her 4th husband.
She said, "I can murder you now."
She really thinks she's equipped to try this case.
She appears very sure of herself.
I have real trial experience.
It's going to be a strange trial. We'll see how it plays out.
The Cult Mom Conspiracy Trial. Live coverage begins Monday morning, only on Court TV.
That's it. I have 2 cats.
Everybody's out?
Yes.
But your stepson's still inside?
Yeah, he's right here.
Okay,
yes.
come out. Come down the road. Come on, come on. That's safe to stay here. Come on.
All right, here he is. All right, my dog is shaking.
I know. Come down here.
That's the stepmother, Kimberly Sullivan, who is getting out of the house, and then her stepson is carried out of the house as well that was on fire. The stepson apparently set the fire. He says he set it because he was captive in the house and wanted someone to rescue him. And now Kimberly Sullivan's been charged with a litany of charges involving what happened to that 32-year-old over the course of years inside that home. Now, that's his step mom. This is his biological mother. And I spoke with her here on Court TV and asked her about, what happened and how her ex ended up with her son and sort of a little bit of the backstory here. Take a listen.
I know when his father and myself were together, he was not a bad guy. I don't know if he was vindictful that we had split up. I don't know. I'm still trying to grasp all this, and it's really, really, really hard. I thought the safest place he would be was with a parent, with his father. And that didn't happen.
And if you are struggling, right, and then you know that he may be able to take care of your son, that was the right choice to make. That's the choice. That's the selfless choice that a mother makes who wants the best for their child.
So. You would think so. He was kept with monsters.
That's Tracy Vallerin. Now, she's the biological mother, but she was never in her child's life. She was never there. Like, she was not a part of what was happening. He was being raised by his father and I guess his stepmother, which brings us to the next question in our investigation. And it's about Tracy. Why was his biological mother not in his life? Was she being kept away from him? Still with us, the attorney representing the stepmother, Kimberly Sullivan. Ionis Kalidas is still with us. Ionis, was she purposely kept away, do you know, by her ex, by the father, by the stepmom?
So, not to my knowledge. It's my understanding, and first off, my heart goes out to her. I think any parent would feel for her, and I understand the whirlwind of emotions that she may be going through as a parent. That having been said, she's never met my client. I don't believe she's ever attempted to communicate with my client. I don't believe she's ever attempted to contact my client. She's, by her own words, has never met my client, but has gone so far as to call her a monster. And that is concerning. As we are trying to ensure my client gets a fair trial, we see a lot of people that are surfacing now, people that have not been in his life, that are quick to rush to judgment and say horrible things about my client. So we do intend on pushing back. So I am sympathetic to her situation, but I don't know what she adds to this case, what evidentiary value she has. Yeah, as far as your question as to why she might not be in his life, I think she's alluded to that herself. I don't have more details. She's alluded to having issues many years ago. I'll let other people get to the bottom of that.
Sure. And what I was wondering from your perspective, if your client had mentioned anything about purposely keeping her out, or if there was a concerted effort by the father to ensure that the mother never had a role in her son's life. But that does not necessarily seem to be the case from your perspective. Let me ask you about the house itself. Who owns the house? Does your client own the house? Does the stepson own the house?
I believe she owns the home.
Okay. And the lock. There's been a lot of talk about a lock being on the outside of the door of his bedroom. Is that something that you concede, or is that a misinterpretation of what the setup was in the house?
So what you're showing there is just one of the many pictures that were released by the Waterbury Police Department. These pictures were released without context, in the middle of a pending case, and we believe they're extremely prejudicial because it's unclear what locks were where. What I can tell you is a number of the interior doors had exterior locks. Those locks, we believe, were in the home prior to my client ever moving in. They were not installed by my client. And there were locks on almost all the exterior doors in the home. So we disagree with the premise that he was ever locked in that room or that any of those exterior locks were even used.
Was he able to walk?
Yes.
Did he have a, do we know if he had a driver's license or?
I don't believe so.
Did he have access to money? Did he work? Did he, I don't know if he worked remotely or if he did anything or had an allowance, an inheritance? Do we know any of that?
I don't know the details of that, but as far as the home was provided by my client. There was food in the home, there was water. He had access to everything within the home.
Did he ever see a doctor over the course of a couple of decades?
I don't have specifics. Based on what he has told police, he did not go to the doctor. But any decision about him going to any doctors, those are decisions that the father made.
And was there any, he's a 32-year-old man living in her home. You're saying it's her home, in her home at that point. Was there ever any discussions about, okay, well, you know, maybe you have to, you know, find your own place, or maybe you have to get a job, or were there any conversations like that inside the home?
I don't know the specifics about that.
And
as far as employment and stuff like that. I have spoken to my client. My understanding is she didn't prevent him from showering, didn't prevent him from eating, encouraged both, is actually my understanding.
And did your client work? Was she home all the time? Does she work? And I'm just wondering, because I'm wondering if there are times when he's home alone or was home alone.
Oh, absolutely. She worked a retail position about 30 minutes away from her home. She worked that position for years. He was home alone quite often, not restrained in any way.
And were there phones inside the home? Like the old-fashioned phones? I don't know if he had a cell phone, but like old-fashioned phones. And then did he have a cell phone?
I don't believe he had a cell phone, but I believe he did indicate to police that there was a landline at one point in that home.
All right. Ion, because we have you on here, I just want to open up. Is there anything else that you want people to know that I haven't asked you about?
Absolutely. Absolutely. The main reason why I came on here tonight is because there has been such a rush to judgment. Almost all the coverage I have seen, respectfully, assumes that this actually occurred. I have yet to hear anyone objectively question any of the allegations. When you look at the pictures, I would ask, look and ask yourself what's not in those pictures. What evidence of restraint do we have? We have exterior locks on all the outside doors. There's no chains, there's no bars, there's no handcuffs, there's no physical marks showing he's been restrained. There's not even an allegation of physical violence to restrain him. There's been a rush to judgment, and I know the whole world thinks she's guilty, and the whole world thinks that we should lynch her without a trial, and that she shouldn't even have a defense. And I'm here to push back on that. This case is far from done. It is far from over. And we intend to fight this. We intend to fight this. And I'd ask people, don't rush to judgment. Because when you see the evidence, it's going to paint a different picture. And what I've told people, there's a long road from allegations in a warrant to provable facts. And you know that as a prosecutor. And this case is going to come down to credibility, and there's a lot to be done between now and the time of trial. But we're confident in our case. Ms. Sullivan has been clear to me that she has done nothing wrong. She has come to me and asked for help, and we intend to defend her. And we're going to push forward, and we're pushing back on the notion that she's guilty and we should just forego a trial. We're looking forward to a trial.
Ioannis Koulaitis, appreciate it. And you know, here at Court TV, you have an open invitation anytime we cover this story. We always want both sides. And I think our viewers understand there's always at least two sides to every story inside of a courtroom. Thank you so much.
Thank you for having me.
Vinny is right about one thing in this, that there is at least two sides to story when it comes to trials, but I actually see three sides, and somehow those three sides converge into one. You have the prosecution side, you have the defense side, and somewhere in the middle lies the truth. And I believe somewhere in this case, we're gonna get to the truth, and we're gonna find out just how much that it didn't happen defense Kimberly Sullivan is gonna work in her favor or not. Next up, we're gonna take a trip all the way out to the UK, where their police has charged comedian Russell Brand with rape and sexual assault. On Friday, British police charged Russell Brand with rape and sexual assault following an 18-month investigation sparked when 4 women alleged they had been assaulted by the controversial comedian. London's Metropolitan Police Force said the 50-year-old Brand faces 1 count of rape, 1 of indecent assault, 1 of oral rape, and 2 of sexual assault. The alleged offenses involved 4 women and took place between 1999 and 2005 in central London and the English seaside town of Bournemouth. Police said the investigation remains open and urged anyone with relevant information to contact the force. In September 2023, British media outlets Channel 4 and the Sunday Times published claims by 4 women of being sexually assaulted or raped by Brand. The accusers have not been identified. The comedian, author, and get him to the Greek actor has denied the allegations, saying his relationships were, quote, always consensual, end quote. Known for his unbridled and risque stand-up routines, Brand hosted shows on radio and television, wrote memoirs charting his battles with drugs and alcohol, appeared in several Hollywood movies, and was briefly married to pop star Katy Perry between 2010 and 2012. In recent years, Brand has largely disappeared from mainstream media, but has built up a large following online with videos mixing wellness and conspiracy theories. He recently said he had moved to the United States. Brand is due to appear in a London court on May 2nd. Jaswant Noral of Britain's Crown Prosecution Service said prosecutors carefully reviewed the evidence after a police investigation into allegations made following the broadcast of a Channel 4 documentary in September 2023. We have concluded that Russell Brand should be charged with offenses including rape, sexual assault, and indecent assault, Noral said. The Crown Prosecution Service reminds everyone that criminal proceedings are active and the defendant has a right to a fair trial. In January, the BBC apologized to staff members who felt unable to complain about Brand's conduct because of his celebrity status. Brand had 2 weekly radio shows on the BBC from 2006 to 2008 and worked periodically on a number of short-term projects. The BBC acknowledged that it was clear that presenters have been able to abuse their positions in the past. So we'll have to see what becomes of this, if those charges stick, what degree and what punishment, if any, Russell Brand may incur. Next up, a Kentucky teacher is accused of soliciting a teenager to kill her husband. Oh, this is not gonna sound good. It's not gonna end well either. According to the Kentucky State Police, an Adair County teacher has been charged after she allegedly solicited a male juvenile to kill her husband. She also faces charges of sexual abuse and distributing obscene matter to a minor. The release states that 27-year-old Elena Barden from Columbia was charged after an investigation into the allegation found that Barden solicited a juvenile male at the Adair Juvenile Detention Center, where she was assigned to allegedly kill her husband. A search conducted on the juvenile's living units on March 27 turned up letters and explicit material reportedly sent by Barden. The material was immediately confiscated, and state police were contacted. KSP detectives discovered the evidence that Barden had allegedly subjected the juvenile to illegal sexual contact and provided him with sexually explicit images of herself in addition to the solicitation of murder, the release states. KSP lists Barden's charges as murder, solicitation, first-degree sexual abuse, and first offense distribution of obscene matter to a minor. Barden was taken to Adair County Detention Center, and the incident remains under investigation. And as the case is still being investigated, when we get more information on the investigation, you'll get it here, right here at Bethea'S Byte Reloaded. No gimmicks, no drama, no BS, just the updates. And finally, one last Karen Reed update. Karen Reed's lawyers appeal to the United States Supreme Court. Karen Reed's lawyers have filed an appeal with the U.S. Supreme Court in their bid to drop some charges against her, and at least 10 jurors have been chosen in her retrial, less than a year after a judge declared a mistrial on the charges she was responsible for the death of her Boston police officer boyfriend. Jury selection began this past Tuesday. Lawyers are seeking to seat 16 jurors, with 4 serving as alternates. Reed of Mansfield is accused of striking her boyfriend, Boston police officer John O'Keefe, with her SUV and leaving him to die in a snowstorm in 2022 outside a house party in the town of Canton. Her attorneys have said O'Keefe was actually killed by someone else, possibly another law enforcement agent who was at the party, and that she was framed. Last year, the judge declared a mistrial after jurors said they were at an impasse and deliberating further would be futile. After the trial, several jurors came forward to say the group was unanimous in finding Reed not guilty of the most serious charge, second-degree murder, and a lesser charge. Despite attempts by Reed's lawyers to get those charges dismissed, she will face the same counts as she did at her first trial. They also failed to have the entire case tossed, arguing governmental misconduct. Alright, so now we're going to go back to Court TV one last time before we wrap everything up. Let's go and get this update on the appeal process for Karen Reed.
Every day we get closer and closer and closer to seating a jury in Massachusetts for defendant Karen Reed. She's in court today for day 4 of jury selection. And so far there have been 10 jurors that have been seated. Now right now the jury is made up of 5 men and 5 women. The court plans to seat between 16 and 18 jurors. The goal was to get a deliberating jury of 12 and then at least around 4 alternates. Now as jury selection moves forward, Karen Reed's defense team is asking for something new, but it is expected. They are taking things to the highest court in the land, the U.S. Supreme Court. They're asking the justices to step in before her retrial begins and arguing that this trial is double jeopardy. It's in a filing that happened Thursday night. Reed's lawyers asking the Supreme Court to consider, quote, a unanimous but unannounced decision by a jury following trial that the prosecution failed to prove a defendant guilty. keep in mind, lower courts have rejected this request to dismiss the charges. The top charge of second-degree murder and the lower charge of leaving the scene that the defense says the jury and jurors confirm that behind closed doors they agreed on those charges but never wrote it down and never told the court. A key figure in Reed's trial is Judge Beverly Cannoni. Here's Court TV anchor Judge Ashley Wilcott with a look at her honor.
We have been unable to reach a unanimous verdict.
After declaring a mistrial in Karen Reed's first murder trial last year, Judge Beverly J. Cannoni is presiding over Reed's retrial.
This is funny, Ms. Reed?
Cannoni, a Boston South Shore native, was appointed a district court judge in 2009 and a superior court judge in 2014.
She comes to this from a defense perspective. That she used to be a public defender, and in fact, her father was a public defender.
Judge Cannoni has had a remarkable reputation as a criminal defense attorney, essentially a superstar criminal defense attorney.
A 25-year career, in fact, defending clients like Reed, accused of murder and other violent crimes. In 2002, Cannoni was named Justice Defender of the Year.
I believe she really does stay above the fray and is not going to be swayed either way, and is going to make her decision based on the best interest of judgment.
She gets a lot of criticism in both directions, and quite frankly, if both the prosecution and the defense are criticizing you, you're probably playing it down the middle. But thus far, even at the appellate level, her rulings have been held up.
Still, Reed's defense team asked Judge Cannoni to step down before the first trial over a social media post alleging the judge knew some of the state's witnesses.
I want to make it very clear that I reject the notion that untrue and unsubstantiated rumors spread on the internet can force a judge to recuse herself. I know full well the importance of a fair and impartial judge. And I know full well how to follow my oath and comply with my ethical obligations. All 4 points raised in the defendant's motion are without merit. The motion is denied.
As protesters rally in support of Karen Reed's innocence outside of court, Judge Cannoni is focused on what's happening inside the courtroom.
She does keep a good, responsible hand in things to make sure that things are moving along, that there aren't unnecessary delays. In a case like this with such complexity, it really could go on and on and on.
Ultimately, the people who matter in this case are the people who sit in the jury box. What she needs to do is ensure that they are not tainted by the spectacle. Ultimately, you're talking about a case that's going to be tried in a relatively small courtroom to a relatively small number of people, and it's going to have, a million eyes on it.
Trial attorney Michael Jaffer, who is with us to talk about the Karen Reed case. And Michael, I feel like I need to have a little asterisk by your name when you talk about the Karen Reed case because you are very pro-prosecution in this case, though we know your opinions are grounded in facts and the law. But tell me what you think about this request to the U.S. Supreme Court and this notion of there being a unanimous but unannounced verdict. I mean, if this was taken up, this would be big when it comes to what happens in the deliberation room and whether or not it could actually impact the outcome of a trial.
Here's my opinion on it. I think it's garbage. I think it's grandstanding. I think it strains credulity to even think that. I really, really believe this is grandstanding. By the way, I want to be clear. If I was her defense attorneys, I'd be doing the same exact thing because I would want to take advantage of the spotlight in hopes that some jurors potentially will see this, because there's no such thing as pure jury sequestration. All the jurors that are going to be the jurors in this case are going to know about this case. Everybody in the country knows about this case. You can ask a barista and she'll know about this case. I think this is garbage. The thought that Judge Beverly Cannoni sent you back to the jury room several times, you first jury, and each time you guys came back and told her, we are hopelessly deadlocked. The jury floor, Judge Beverly Canoni wasn't in the room with you. She wasn't taking notes. She didn't tell you that you're deadlocked. You told her that you're deadlocked. You specifically told her, we are hopelessly deadlocked. You used adjectives to Judge Beverly Canoni, begging her not to send you back into the room. I'm offended by this. I feel insulted. My intelligence is insulted. And I absolutely detest this thread, this line of logic, because in my opinion, this is to the jurors, you're either the dumbest people or one of you is lying. And I don't think it's the first thing. I think someone is lying. There is no way that Judge Beverly Canoni sent you back multiple times, and multiple times you told her we are hopelessly deadlocked, but you were unanimous on the top charge. It makes no sense. So what are we doing here? This is completely farcical. There's just no way that happened. One more thing. How could you be unanimous on the first charge and third charge, but not be on the second charge? It sounds to me like somebody's just lying.
Oh, Michael, it's not just one juror that's saying that. There have been several jurors who have come forward. I believe at this point it's the majority of those 12 who have come forward to at least the defense, the media, or to the prosecution to say, yeah, we were unanimous on not guilty. I agree with you. It's very weird that they at least didn't ask the judge, because I have seen that. I've seen jurors not know that they can bring back a partial verdict, but they will ask the judge, what if we're hung on one charge and not on the other? We'll see if this even gets reviewed by the Supreme Court in the amount of time, but the odds are that it is not, and we are going forward with this trial. But in talking about the jury, we've had some viewer questions about sequestration. You mentioned there's no pure sequestration, but why do you think these sides haven't asked for any kind of sequestration, even a partial? Once the verdict, or once the jury is deliberating, they could just have them sequestered for that point in time.
I think the day and age that we live in, right? If you walk past that courthouse, your phone identifies that you're there, and it feeds you stories, and you start ingesting stories about it. I think it's just the law has not caught up. These sequestration rules were set up in a time before social. They were set up until 10 years ago, 15 years ago. They work. They just don't work. I think the system's trying to catch up. I think at this point, if you're like Hank Brennan, for example, all you can hope for is you have a jury pool that does not have people who believe the earth is flat, complete morons, because that's what you need in order to believe the Karen Reed defense Bigfoot theory, right? That's what you need to believe it. So I think you just hope that, hey, we're not going to sequester these people. There's nothing we can do about it. Let's just hope that they're not complete morons. And after the first trial, a tear-soaked friend of John O'Keefe said that during the over 27 hours of jury deliberation, they kept hearing "Free Karen Reed," that silly chant, in their ears. So I think all they can hope for now is just to keep the public away and just hope for the best for the train wreck. So that's why I think that, Julia.
Michael Jafer, thank you for your analysis.
Thanks to Julia Janae for this coverage. We'll have to wait and see what becomes of this appeal. Now, will those charges get dropped or not? We'll just have to wait and see. And again, I stand by what I said earlier. I've stood 10 toes down on this before, and I'm standing 10 toes down on it now. What should have happened is that, sure, man, it would have taken longer, but what should have happened was that the jury should have been polled from the beginning. That way, once we do get to a retrial, it would have been probably under lesser charges. But I'm just saying here. All right. Oh wait, I almost hit the wrong thing. Before I wrap things up, I want to direct your attention to a post I made in the community section earlier this week, and I'm directing this to all the creators that's supposed to be dealing in true crime, but it seems like they're more interested in drama. This is the post here, and I simply said here, excuse me, but is there anyone still involved in the true crime in this community? All I've been seeing is nothing but drama and crama posts. I've got a challenge for all of you. Next week, I'm extending the invitation to all of you to join me right here to talk true crime cases. I'm extending the invitation to actually give you a break from acting as if this is a digital rewind to middle or junior high school and high school. We are so much better than this, and you have the chance to prove it. I, as always, will gather up a week's worth of stories to discuss. We'll talk, we'll debate, we will not take personal digs at each other, and we will stick by this policy, which is my guarantee. I'll scroll it by at the bottom real quick for you. There it is. No gimmicks, no drama, no BS. So, if you're true crime, join me. If you're drama, the next comments you make about anyone else, I urge you to stop and take a look in the mirror. Meanwhile, I'll see you right here at the drama-free true crime destination. Until then, bite this. Remember, this is my guarantee. No gimmicks, no drama, no BS. I will see you right here. But for now, that's going to wrap things up for me right here at the drama-free true crime destination. I want to thank you all for joining me. I want to especially thank April T for joining me in the chat room. She's been great with her opinions. I hope everything is safe. And whatever you miss, April, come back in the for the rewind, and you can get everything that we got there. And I would love to hear your commentary on top of that. All right. So, but as far as getting a hold of me, and especially all of you who wish to take me up on my challenge, let's see. Here's what you do. If you want to hit me up on Facebook, I'm at Bethea'S Byte Reloaded. On X, I'm at EKB316, all caps. Here on YouTube, like I said, you can hit me up right in the community chat, in the community section. It's at Bethea'S Byte Reloaded. On Instagram, I will link this video to there as well. It's at EKB316, all lowercase. On TikTok, while we still have it, I'm at King of Hearts 316 2021. Or you can email me. My address is kingofhearts316_09 at outlook.com. All right? I look forward to hearing from you. This is the home for true crime news without the drama, where your opinions matter. Lively debates are encouraged, where your voice is heard, and above all else, it's justice served. And again, my promise, my guarantee, no gimmicks, no drama, no BS. That's the way I do it. This is Bethea'S Byte, and it's reloaded. I'm Ernest Bethea, the last outlaw. Thank you all so much. I will see you again next week, and I hope the true crime community joins me too. If you're not in the drama or anything. Until then, you guys know what to do. Bite.
Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe to the channel, and drop me a comment on this video. Also, be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.